No mention there. Give the slip to the court officer. No mentions. Yes.
Yes, sir. So writ against Your Honor, inaction on the part of the respondents in not disposing the application dated 23/9/2023. Complaint was made against the unauthorized construction. Permission was accorded for still plus 2 floors, and construction is made for still plus 4 floors. Your Honor. Page 19, Your Honor, is the permit, building permit order, which is very clear that it's for still parking plus 2 upper floors. I filed the photographs, which shows construction is for 4 floors, Your Honor, still plus 4 floors. Page 13 is my representation to the municipal commissioner.
What is the page?
Page 13, dated 23/9/23, Your Honor.
Yes, Ramsuru. Take action. Take action. See, when somebody is making construction beyond what is permitted in law, what is permitted is only 10% in terms of GO 168. If there is any deviation beyond 10%, you are duty bound to take action. You have issued notice. You have already initiated action. 1 second. We'll record that also. Right. This petition is filed for issue of a writ of mandamus.
Please, your lordship. Aggrieving by the action of the respondent number 3, my lordship, they have permitted the respondent have permitted number 6 to construction, my lordship, on the common area of the building where water tanks are kept.
Hmm.
Such construction, when the petitioner walked into the GHMC to inquire about the same, they have said that don't interfere in it. It is being constructed as per the permission.
Hmm.
And they are refusing to give such permission copy towards the same.
Where is the
And-
application under RTI? Where
Lordship.
have you made application under RTI saying, please give me a copy of the permission?
RTA copy, it is a direct walk-in when he went and we have
Walk-in,
requested your lordship.
That is why RTI Act has been enacted, saying that you make it 10 rupees, take a postal order, 10 rupees, ask for information.
We have
They
We have
say
given a
that they have granted, they have not granted.
now the petitioner has given a representation also, your lordship, to the commissioner of GHMC and
Today you are saying that they have not given you copy of the building permission.
yes, your lordship.
If that is the case, you should have asked for a copy of the same under RTI Act. Have you asked it or not?
Meanwhile, the construction is undergoing and it has been
That
a
is why I am
problem.
saying, if you only ask for such information under RTI Act, whether it is with the permission or without permission, you will get to know
Yes.
whether they have granted any permission or not. If no permission, then it's a illegal construction. If there is a permission that is granted, then under what authority that is granted should be questioned. These are the two things which you need to follow.
Meanwhile, your lordship, when representation is,
First, you are not understanding your
I-
own case and you are saying meanwhile.
no, your lordship,
Come to this court saying meanwhile, we can't help it.
representation was also,
This is your case.
representation
The
was
dif-
also made, my lordship.
The difficulty in your case is you have made certain statements without taking steps for seeking that information under a enactment. We can't come to your rescue. You should have said, I have asked for the information by making an application under RTI Act. 30 days is over, no information is furnished. Therefore, I have to presume that there is no building permission, or the authorities are in collusion with the person who is making unauthorized construction. Nothing is done. Simply file a writ petition.
We have made a representation also, your lordship, to the commissioner and GHMC deputy commissioner stating that to stop such illegal construction if any permitted or to withdraw such permission if any in common areas, your lordship. In the page number 23 and 24, your lordship. And in accordance with the Municipality Act 2019, Section 174, approval of the building permission, no piece of land shall be used used as a site of construction of a building, or no building shall be constructed or reconstructed.
You are referring to which act?
Municipalities Act, your lordship.
The area is under which act?
GHMC Act.
Then
GHMC Act.
which act you have to refer to?
GHMC Act, Section 2 of the GHMC Act also states that
Says what?
any such building includes the shed is also included as a building, and such permission has to be obtained.
Where? Which provision?
Section 2 of definitions.
Building 2(5) defines building.
Building, your lordship. In the building, it says that a shed even
Includes a shed, a hut, everything. But
Yes.
this provision says that he is required to obtain a permission for construction of a building.
approval of a building permission is
Under which provision? Like you have referred to 174 or
Yes.
176 of which provision of Municipalities Act? The GHMC Act specifies that.
any building permission which has to be approved legally, your lordship.
Which provision? I do not know. I am asking you. You are the counsel. You have taken the responsibility to argue the case of the petitioner.
Yes, your-
So you should tell the court, under this provision, there a building includes a shed
Shed.
also, and this requires permission under so and so provision. Tell us.
The Municipality Act implies to the state, so
Is Municipality Act applicable to Hyderabad?
no.
That is the end of the matter. Then keep aside that book. Give it to somebody who needs Municipality Act. If you want to rely on GHMC Act, tell us the provision, shows the provision which requires permission. Don't look at others. You look at the book and tell us. When did you enroll?
21 year Lordship.
2 years are over now.
Yes.
Hmm? You have not even bothered to look at beyond section 2 when you are filing a writ petition. Hmm?
I was going through this municipality act.
You are looking at a wrong provision, wrong enactment. Why did you look at Indian Telangana Municipalities Act? You should have looked at either Delhi Municipalities Act or American Municipalities Act, if there is any. First,
My apologies.
you should know which enactment is applicable. Make some effort, come back after the pass over. I will pass it over.
Thank you.
Come back in the afternoon.
Obliged.
Pass over. Sit in the library, go through the GHMC Act, tell us which provision requires, then we will learn.
C437. Actually, the action of the respondent will be invoking the building code.
When, 1 second, when is the TSB pass approval taken? What is the date?
6/9/2020.
1 second, 26/9.
Revocation dated 23/10/2020. Okay.
1 second. So when does 21 days expire? From 26. Four days in October, 27, 28, 29, 30. Huh? 18, 18, 11. No, yeah, 1 second. September, no? September 26, 27, 28, 29. Correct? 4 days there. Then in October 18, 17. So 17, 10, it expires. 21 days expires. Because I have already taken a view that within 21 days, no notice is required. It's only after 21 days, it will be treated as a deemed approval. Thereafter, only the commissioner is bestowed with the power. Huh? Yesterday also, then previously also passed an order. I have interpreted that section 7(9) and 7(11). What is this? Now, who passed the order? Then he doesn't have. Beyond 21 days, he doesn't have. Only commissioner has. And in one of the matter, today's matter, it is only the commissioner who passed an order. I think item 5. Item 5, check whoever is appearing. It is the commissioner who passed. So therefore, they are fully aware that who is required to pass the order. And in fact, commissioner now should initiate action against the authority for not causing post verification within 21 days. That is what the section says. I am not saying anything. Section itself says when commissioner invokes his powers under 7(11), he should also initiate action against the officer for not causing verification within 21 days. So we'll have to set aside and say that commissioner, it is only commissioner under 7(11), and he should also take action against the concerned deputy commissioner. This is how they are helping, madam. Simple thing. Passing an order after 2 days gives them the right. When the building permission becomes a deemed approval, thereafter, what is the commissioner can revive only by issuing a notice. So the time is enlarged, they will proceed with the construction. That's why your officer should also suffer.
She may remand it back.
No question of remand. Remand to an authority who lacks jurisdiction now. That is not permitted. That is commissioner, but commissioner should also look into his powers that when he is invoking section 11, he should also take action against the authority. That is what section says. I am not saying. In fact, we used to have one professor in law college. He used to tell us, who says Section say. Mr. Dhananjay Reddy will also know. Hmm? No, it is, I am not saying anything. Please look at your section 711.
7/11/23.
Permission deemed class can be revoked by the commissioner within from the date of deemed approval if it is found that deemed approval has been obtained by misrepresent so and so or against building rules. Consent 10. If no order is issued on the building application within time prescribed, then the approval will be deemed to have been issued as may be prescribed. The official consent shall be liable for the disciplinary action if there has been a delay in arriving at a decision within the period. So he is liable for disciplinary action.
Let decide the matter of the deliberate.
Madam, we'll have to put sensitize them. This is how they are helping. Now I will tell you one more difficulty. Today, if the commissioner, the file has to be moved to the commissioner. Then commissioner will issue a show cause notice. They will go to some civil court or some high court. If there is a change in bench, come before this court, file a writ petition, get a order notice issued, everything gets stopped. That is the end of the matter. Correct, madam. But that building permission is now deemed approved.
How do we have not- how do we-
All that is fine. That the authority should have done within 21 days. If he has not done today, he will say that my building application is approved. Deemed approval. He will go under deemed approval. In case of deemed approval, who has got the power? We can't this thing, and we'll say that it is only the commissioner, and commissioner should also take note of the fact of the dereliction and abdication of duties by the authorities. And this writ petition is filed. See, there are two stages.
Yes, yes, 21 plus 21. Right?
First one 21, second one 21.
Yes.
Ah. This is how the officers are colluding. The entire Sherlingampalli, I myself brought to the notice of the commissioner. I called him and cautioned him that Sherlingampalli is one collusion. Then there is another area. Mr. Dhananjay Reddy, which are the areas I told your commissioner that day? Rajendra Nagar. No, Rajendra Nagar is, you see, there it is collusion, Sherlingampalli. Here it is political interference. I am conscious of everything. Malakpet, I brought to the notice of the commissioner. Yes. Admit.
Your order is passed by your lordship.
No. Yesterday I passed a different order. Matter is fixed before the Honorable Division Bench on 15. Therefore, I have recorded 1499 of 2018. The Honorable Chief Justice directed the matter for listing for final hearing on 15th November. Makta Mahbubpet.
No, it is not. Sorry.
No, please.
It is wrongly recorded. That's why I wanted to bring to your lordship's notice. The sheer non-application of migration.
No, but Makta Mahbubpet you said in the prayer.
No,
Please look at. That is why I am saying.
the page 4 of
1 second. 1182 square yards, Makta Mahbubpet.
Panamet. In the impugned order, it is written as Mahbubpet at one place.
That is what I remember
But
reading.
go to page 15 now.
Because Makta Mahbubpet is now listed before the Honorable Chief Justice for final hearing on 15.
Not that village, it's Panamet. Page 15.
Now go to page 16. Makta Mahbubpet is recorded.
Thereafter, lordship, can you take the next line, my lord, again? I'm sorry, my lord, bottom, 5, item 5. As per the report of Rangareddy, revenue officer, dated so and so, in view of the above, it is submitted the request of issued NOC for building permission, survey number 41/5, extension of Kanamet village. That Mahbubpet, I think, my lord, is cut and paste, my lord, mistake. And my application also, my lord, if lordship sees, my lord, the first page on page 15 also. Page 15. Subject itself, my lord. It is cut and paste, my lord, mistake.
Which is my order.
Your lordship's order, my lord, page number 4270. Para 10, my lord, your lordship.
Page number.
Page number 42, it starts, my lord, para 10 on page 47.
47. 1 second.
And in this case also, my lord, they refer the matter to the district collector, who page 41 says, I will not issue NOC.
No, but is the ground of rejection
Yes.
on NOC?
Yes.
Where is that?
Page impure proceeding, page number 15, my lord. Page number 17, the first line. As per the report of the district collector, RR district, the subject land in survey number so and so is classified as government land and rejected the NOC. Hence, proposal may be rejected. They also refer to some shortfalls, that's non-compliant. In fact, we have complied with, we'll again complete. That is not a problem at all. But the main ground is, my lord, the letter of the collector, which I also filed page number 41.
Yes, madam.
As per my instructor, it is a government land.
No, that is true, but how do you get our orders, batch of orders? Not only my order, I only followed earlier orders, and also I think there is a writ appeal.
Yes, that was
That has also been finalized.
Yes.
So once a writ appeal is, what is the writ appeal number?
62, page 62.
Writ appeal, page 60
Writ appeal number 403 of 2022.
of 2022.
Yes.
By which order in WP number?
That is against order in WP number 16868
16868
of 22.
of 22 has been affirmed.
Affirm. Yes.
So what remains, sir? Single judge cannot sit in appeal over division bench order. Right? Yes. ये मक्ता महबूबपेट किधर है, ये कानामेट किधर है? नहीं, अगल बगल में है या कहीं दूर है? मक्ता महबूबपेट, if I know that it is beyond that Kukatpalli.
Yes.
Hmm? Hmm. Huh? Hmm.
The present date is filed agreed by the action of responding to passing the rejection of the on beyond of the proposal beyond time of described by the TSP pass and taking steps to remove the section.
1 second, when was the application made online?
12 January.
Hmm?
12 Jan.
12th January 2023.
Yes.
Hmm.
Rejected my application was on 9th March 2020.
9th March 2023.
Yeah, beyond that, almost 55 days.
1 second. Who has passed the order? Beyond that, he's got the power.
But according to the TSP pass notes, we have to be take steps only within the 21 days notice.
No. That we have interpreted, Mr. Counsel. That we have interpreted. How, within how much time? 21 days, the concerned authority, that is the deputy commissioner, who grants the building permission. Beyond 21 days, it is only the commissioner.
They did not give any notice to be.
1 second, that we will see whether a notice is given or not. But commissioner is the authority beyond 21 days. That is what I held just now in item, madam? 3, item 3, not only today, already decided, matter is already decided. But
Schedule B, clause 3, clause 1 of the amended building rules.
Act will prevail or rule will prevail? Tell me. Over. Look at 7.
He is relying upon Telangana building. Look, I'm Telangana book point side.
They have to.
No, but all that is fine. 1 second, let us see the impugned order. Any notice is given to you? Rejection letter is issued by the commissioner. So to that extent, he has power. Is it preceded by any show cause notice, Mr. Dhananjay Reddy?
No idea.
That is what is needed. If no show cause notice, it doesn't convert, they are required to put him on notice because it is not a automatic rejection on by causing verification. Pass over?
Relying upon some civil court order. We can say the reason is mentioned.
No. All that is said. I am only concerned about notice being issued or not because power is sought to be exercised under 711. In which case notice should be given. That's all. You will verify and tell us post lunch. If it is what taking step. You have managed them so well. Manage them for 24 more hours.
This birth.
No, you have managed them well from February, March. When is 1 second? When is the impugned order passed? We'll now go one step by step. Then we will get the answer. 9th March. Today we are in what date? No. When was it served on you? We'll now put a question to you. When was it served on you? And what were you doing? When? 9th March is the order. When was it served on you? Where have you stated in your affidavit? 1. 2. The delay. Any writ petition filed beyond the expiry of the limitation period for filing appeal need not be entertained. Supreme Court judgment, I will give you. A sales tax matter, Devandama. Judgment. We'll use that and knock off your writ petition. That will be best, no?
After tomorrow.
Day after tomorrow is what date?
Friday.
It's the-
Monday. They can wait for 6 months.
Friend,
CR, civil court order not, that not CRP not.
we are not concerned anything, only on the legality of the order, that's all. I am only confining. If we start going into the merits, you will have to go to Chief Judge City Small Causes Court. Remedy of appeal 654, 655. Because you said no notice of violation of principles of this natural justice, I am entertaining the writ petition. Otherwise, your remedy is elsewhere. And GP for MAUD takes notice for one. Sri M. Dhananjay Reddy, learned standing counsel. Next week, Thursday. Yes. That will be on 16th, DL1. Yes.
Item 7,
Huh.
So may permit me to.
You are for
Lordship, impugned order page,
petitioner.
for the petitioner, Your Lordship. Petitioner counsel is requested. Lordship, but page 16 is the impugned order of revocation under 176(9).
1 second. Oh. Yes, yes.
The Lordships will kindly take page 22. No show cause notice issued. Directly a hearing notice is issued on 27(9), asking the petitioner to appear on 410. Upon appearance, the building permission is revoked. The basis for complaint, none of that is shared with the petitioner.
Is your officer a judicial officer? He passes an injunction order. Please look at the order. All that is fine, Mr. Surendra Reddy. What the parties cannot get in a civil suit, he is giving it indirectly. Please look at the order. He is passing it. That's why I got it out whether he is a judicial officer by any chance. He deals discusses so many things. Huh? In fact, I will come to Brother Shravan's order also. Go to that order. What did Brother Shravan permit you to do? Read para 5. When was the inspection conducted? He doesn't mention. No, he doesn't mention the date, Mr. Surendra Reddy. I am telling you. Please read the order. Show us what date they have caused inspection pursuant to the direction of Brother Shravan. First, they should conduct inspection. Thereafter, issue hearing notice. Where is that? Please show us from the impugned order. No, please look at, please. No, please tell us. Horse before the cart or cart before the horse? No, that itself shows two things. One of the thing would be correct. Either the officer is acting under the influence of the power, or the other side, or else in dereliction of duty. Which one you take? Which one you want me to put it on record? I'll put it. One of the two only you have option A or option B. Which one you want me to put it on record? I'll put it on record. No, inspection should have been done before issuing personal hearing notice. Without causing inspection, whether there is a construction in deviation of whatever it is, how will the authority come to know? Is it not, the court did not direct him to do postmortem. They said, please administer oxygen, see whether he survives. If he doesn't survive, then do postmortem. It is not that you do postmortem, that means kill the person, then do postmortem. And thereafter provide oxygen. That can't be allowed. No oxygen can be allowed to be put to a dead body. That clear? That's why I said option A, option B. Which one you want to put as on record? The officer is acting under the influence of the unofficial respondent due to his political affiliation or in dereliction of duties. Which one you tell us? Choose the A or B. No, there is no option C. None of the above, not there. Only A and B. And this way it can't be allowed. When we will set aside this. Whatever follow, whatever Brother Shravan directed, follow that. And virtually has granted an injunction order. Page 17 is an injunction order. While the civil suits are pending, they were unable to get injunction. All that is fine. That is why they are required to cause inspection. And where is that in the notice mentioned? This writ petition is filed. Is set aside or not? Right? Is allowed. Accordingly, the writ petition is allowed. Yes.
At least. And the grievance of the petitioner is, my lord, where my lord, illegal constructions, my lord, in the parking lots, and my lord, municipality initiated action. And my lord, the fourth respondent, builder, and who is also representing as the president of the Flat Owners Association, my lord, he filed a suit and obtained injunction in the month of January. February, my lord, they filed a counter, my lord, seeking to vacate. From February to my lord till this date, my lord, they go going on adjourning the dates, my lord, they are not taking any steps to seek vacation of the status quo orders. I am relying upon two division bench orders, my lord.
Tell us, we will pass an order. Please tell us.
Yes, my lord. Sir, one particular, my lord, judgment of my lord, lordships, my lord, Justice, Chief Justice and my lord,
Please.
Chittorakaramji, my lord, they said, my lord, if status quo order was granted by the civil court, my lord,
No, we are not sitting in judgment over that. Your grievance is,
my lord, they are hand in glove, they are collusion.
no, whatever it is.
Municipality.
We will deal with it. Please tell us which is the judgment.
Yes, my lord, page 46, my lord.
Page 46.
My lord, the relevant portion. Where, my lord, a suit was filed and status quo order was obtained. Page 46, my lord, last
Yes.
3 lines. A status quo order was passed. When a status quo order is passed, it does not mean that GHMC and its officials shall adopt a hands-off approach and allow respondents 6 and 7 to carry on with the construction, rendering the demolition notice redundant. Well, this is one observation, my lord. And another, my lord, division bench, my lord, held. My lord, I reproduced, my lord, in my affidavit. Lordship may kindly see, my lord, page 3 of my affidavit, where, my lord, interim order was passed by the civil court. My lord, page 3, we have perused the interim order dated so and so passed by the learned first civil judge, and are prima facie of the view that the court should not have passed an unrestricted injunction. It was passed, my lord, without, my lord, notice to the municipality, without hearing them. Lordship may kindly come down, my lord, bottom. A list of the cases in which applications may have been filed by the municipal corporation or any of its functionary for vacating the ad interim injunction must also be supplied to the Chief Judge, Citizen Court, Hyderabad. On receipt of such lists, the Chief Judge should transfer all the cases to 2 courts having jurisdiction over the matter. Presiding officers of those courts must within next 60 days dispose of the pending application in which exporting injunctions have been passed against the action taken by the municipal corporation and its functionaries for demolition of illegal constructions. Two division benches. Yes. Yes.
What is the relief we have now asked? Please go read your relief also.
Yes, my lord. My lord, relief, my lord, mandamus, my lord, in not taking steps in getting the impugned order vacated, which is in violation of Article 21 and all this, the main.
Can that be granted and a writ of mandamus? Please show us.
My lord, I am only questioning the inaction. My lord,
That is true.
inaction of, my lord, the municipality.
That is true.
My lord, I am only praying for a writ of mandamus, my lord, to command
No,
the
no,
municipality to
Whether
take.
such an order can be granted when you have other course of which I will put it in the order. I'm only asking because you are a senior person. I'm asking you that whether such a relief can be granted. Because we would like to, I would like to dismiss the writ petition with exemplary cost. I'm making it very clear. I will justify, I will dictate the order on the bench itself.
My lord, my grievance is.
All that is fine. I'm only asking whether such a relief can be granted in a writ of mandamus. Please
My
tell.
lord, I am seeking relief, my lord, against the municipality.
There are, I will put it in the order what reliefs you can otherwise can get,
My lord,
but not in the form of a writ of mandamus.
and my lord,
That's why I'm only asking you, please address if you want to make submissions. Otherwise, I will make the order and we will dismiss. I'm making it very clear. I will dismiss the writ petition because the petitioner is an advocate.
yes,
He should, and I am sure he has already put in more than 20 years of practice.
it's not.
He should be aware what orders, what is the scope of a writ of mandamus, to what extent we can exercise our jurisdiction under Article 226. Therefore, I want to dismiss this writ petition with exemplary cost.
No. Lordship, kindly consider.
We
My lord,
should,
it's a case.
you see, if an advocate tries to take advantage and abuse the process of law,
My lord, it is not a
He should
case of,
he should be put in place.
my lordship, kindly see, my lord, it is not a case of abuse or process.
No,
My lord-
please allow me.
My lord,
Please allow me to dictate the order, then test my order. I am making it very clear.
my lord, I'll take steps, my lord, to, my lord, another.
That is what Mr. Council, you are seen, Mr. Velu. I can understand a pressure coming at the bar with a 2 year or 3 year or 5 year approaching this court. In fact, I did not expect you to appear in the matter. I am making it very clear. Yesterday night when I read through the bundles, I did not expect you to appear. I thought maybe one of your colleague will appear.
I got convinced, my lord, with those two division bench orders.
You see, I am telling you, I myself passed the orders where status quo orders or injunction orders against statutory notices are being granted by the court. I have referred to Philomena Educational Society's order and said the civil court does not have power to grant injunction against status quo orders against statutory notices. In fact, I have also referred to office orders passed by this court, sensitizing all the judicial officers then. Since it is over a period of 10 years, I have asked the registry to renew that office order once again by sending that to all the officers concerned once again. But the petitioner is only trying to, he is an advocate. We all know what the act. I was also an advocate, not that once an advocate, always an advocate. That stint doesn't go. So he is only trying to show his, the power and the primacy that court is my this thing next home.
No, no.
I can get do everything, get done. I will show my
My lord,
power.
I'll take steps, my lord. I'll look into
Simple thing.
remedy. my lord.
Remedy is he filed an application to implead and get it vacated. Simple 1 minute job.
My lord, we thought of that also. It will take time, my lord.
Nothing
Time
out of
and all
1
that.
second. Show them the order of a division bench in Philomena Educational Society. 1. 2. The High Court office order. Where this High Court after that order is passed, because in that judgment itself, this court said registry is directed to issue an office order sensitizing all the judicial officers that they should exercise a restraint when such proceedings are. That is the end of the matter. Any judicial officer will not act in defense of the High Court office.
Liberty, my lord, to take appropriate steps.
After making initial submissions, counsel for the petitioner seeks permission of the court to withdraw the writ petition with liberty to approach. We have not allowed legal services authority to get 25. Nine and 11 go together. Yes.
May 2023 was the permission grant.
Hmm.
Not the.
Now you know. Now you know. It is in time. Please look at the proceeding.
5/9/2023 was the not the approval of the delay submission. But within 3 weeks, on 25.
No, 21, 5, 9, 21 days. 26, 26. Yes.
From the date from another 7/11, within 3 weeks from the date of deemed approval,
Correct.
which will be happening on
14th of?
14th of October.
Huh.
Now this order is passed on 17th of October
Huh.
and passed by Deputy Commissioner.
No. Deputy Commissioner, what is the date of the impugned order?
Not impugned order is dated 16/10.
1610.
16/10.
1 second. 1610.
5/9/2023. Permission.
So 5/9 to 21 days.
5/9 will be on 25th.
Huh?
25th.
Of
25th of September. 5
26.
plus the
1 second.
21 days. Will be
26th of the 26th September is the 21 days over.
Then
So the
thinking from-
impugned, 1 second. That we will examine,
Yes.
not in this case. That we will see, because the impugned order is deputy commissioner.
Impugned order is given by the deputy commissioner.
So he has no jurisdiction beyond 21. That's all.
Not done. One more thing, they also see the property.
Yes, Praveen. Item 3, same order. Beyond 21 days, deputy commissioner doesn't have power. Yesterday also I told you. It is only the commissioner beyond 21 days, commissioner.
That is there, Milord.
We'll have to set aside this.
Okay.
Now, answer to your other point, I will tell you after I dictate the order.
The
There is
revocation.
one more provision which you are all not looking into.
So this court, I just put get this ground after hearing the last. After ground was under 17, they were supposed to give a notice before this revocation. That is also not given.
No, for the deputy commissioner, you see, I've already interpreted that provision and said if it is within 21 days where they are required to cause post verification, no notice is required. That's a verification. It is not shortfall, whether whatever you have mentioned,
Inspecting, that's what.
that is an inspection based on which they give a work commencement letter. So therefore, no notice is required. Like they do not need invitation from you to visit your premises. Similarly, you are not required to be put on notice when they will be coming within the 21 days, because you have made an application. I am coming you to inspect there and see whether, yes, this meets that requirement. The land, let us say I have obtained, you see, TSB pass online process is a mechanical process. I will say 1000 square yards, I want building permission. You enter 1000, it is printed. It is printed. So a copy of that is also printed with me as a municipal authority. What I will do, I will take that copy, come to your site. See, first of all, there exists 1000 square yards plot or not. Let us say when I come there, instead of 1000, I only find 100. So by giving permission, what I will do, if at all, without causing inspection, I will be giving you authority to demolish the construction which is around that 100 square yard, saying that I have obtained permission, therefore this is all illegal. So to prevent that, the authorities will come to the site, cause inspection, first to see whether there exists 1000 square yard for which you have obtained online permission, because it's only provisional permission. Condition number 1 of the permission says it is subject to post verification. Condition number 20 says that permission is only provisional for the purpose of availing financial assistance. So the intention of this generating this permission is you will be able to approach the authorities, the bank, financial institutions to generate a loan for taking up construction. Then the first this thing is within 21 days, the authorities are required to come to the site, cause inspection, whether actually you can make construction or not, ascertain, then issue work commencement letter. Thereafter only you can take up construction. This is all should happen within 21 days. Yes, yes. No, that's what I'm saying. That is post verification.
During the verification process.
That's what I'm saying. They have the power to cause verification within 21 days. Once they visit your site, if there are any shortfalls, that should be communicated to you within 10 days. Otherwise, the moment they, Madhav, I'll put it this way. Today, 10 days is for communicating shortfall, if any. If no shortfall, work commencement letter will be issued on the same day. It is only after the work commencement letter you can actually start construction. That is why the procedure is, if the authorities do not cause inspection, then it is treated as deemed approval on 22nd day. That is the scheme of the act. And let us say on 21st day, they come, inspect, notice a shortfall, and they don't issue a work commencement letter, and they notice shortfall, they are required to give the shortfall intimation to you, which you can rectify. It's a, you see, shortfall intimation is requires you to rectify. Work commencement letter means everything is in order. You can start by maintaining the setbacks, whatever it is. That if they don't give, it is treated as deemed approval, and thereafter the commissioner can only review. And one more, now last I will tell you. 711 is not the final thing. 711 if they want to exercise power. Otherwise, if you look at section 24, only where it is inconsistent to the other enactment. Now, after, let us say, within 21 days, the commissioner does not, because you are telling to Sridhar, that's why I am telling you. After 21 days, let us assume after 21 days, even within 21 days, commissioner does not exercise power. It is not that the commissioner also does not have power. He still has the power under section 450 because 450 and 437 because it is not inconsistent with the act. This is the entire scheme of the act.
So to clear, even after 21 days, the landowner has to give a commencement letter under section 435.
No. That is not required. That is not required under if your building permission is obtained under TSB pass.
Yes.
That is the oldest system. That's why I'm saying this still the power. That's why only where it is inconsistent. Section 24 is. Otherwise, Parent Act will provisions of Parent Act will be applicable. This is the entire scheme of the act. Look at the one season we have done mastered the Excise Act. One season Municipality Act. Municipal GHMC and Municipalities Act. We'll have to set aside this because Deputy Commissioner passed who lack jurisdiction. Tell us only whether within 21 days or not. That's all. If it is within 21 days, we will not interfere.
The revocation already order has been passed.
Without authority of law, without jurisdiction. That is what I have held in the morning.
Deputy Commissioner, the order have been passed, the speaking order dated 39/2023. But the Commissioner authorized on behalf of the Commissioner, the Deputy Commissioner can pass
There
an
is
order.
under the, it should be under the act, not by letters.
But not.
The delegation should be under the act. Commissioner, the powers which the commissioner can exercise are also accessible by the Deputy Commissioner. So authorized by the commissioner should be your provision.
Yes,
No, in fact, in one of the matter, today there is a proceeding passed by the commissioner. That means he is fully conscious of the fact that it is only the commissioner who has the power.
Yes, but the access or and whereas in one.
All the problem is your officers, instead of going to commissioner because they will get a wrath of the commissioner, they are passing these orders.
But the subsequent to speaking order,
We are not examining the ground. Ground of revocation can be, if at all. No, you will have to go to civil court. No, we will not examine. You see, once you are challenging on the ground, the validity, the order, that reasoning is not correct, we will not entertain 226. Then it has to be 654, 655 of the Act, GHMC Act.
This particular provision is not covered.
No. I will tell you. 1 second. That is wrong. 655 demolition. What is the final part of the order? Remove the unauthorized construction. So that gets covered by 655. That also I have already held. I think 2 months all these issues have been trashed out. Ironed out. The only thing is whoever comes have to implement pass that order. That's all.
All the situation comes at right.
Better not to avoid this bit. Unless until the standing councils acquainted themselves with all the case law which is passed by me in this 2 months or 3 months.
Then making note at all the case laws.
No, we'll set aside. Automatically it is.
I have this matter tomorrow, 2 matters. I'll get written instructions pertaining to same. Tomorrow only.
Today is Wednesday.
Yes, tomorrow, because the after.
Tomorrow for orders. Immediately after motion for order. With the request of Sri Praveen Vidyala, the standing council. Actually, is that I've already told the commissioner. We know which which circle officers act for other reasons, which circle they act under pressure. Yes, next. Same, 9 and 11 go together. Hmm.
The petition made a representations 18/7, 28/8, 9/10.
18?
18/7,
18/7,
28/8,
28/8,
and 9/10
9/10.
to the authorities to requesting to take action against the respond number 7 and 8 who constructed the 6th floor building but without any permission obtained from the authorities. But even before making the representations, the petitioner made a representations in the month of March and April, requesting the authorities to provide them the permission whether the respond number 7 and 8 have obtained the permission from the authorities or not. We have specified what the requirement. They have
Provided there is an appeal to.
they have not. They say
They say it is not traceable or difficult.
they say because the permission number is not right, not traceable. That's what they say. Though I have given the house number and everything, house number is there. Once they can provide. No, I am not aware. I'm not on that.
If you are agreed by that order, there
I
is
am
an
not.
appeal. There is an appeal to the.
No, that is correct. But I'm
Under the
not-
RTA Act.
After that, the petition made a representation specifies, mentioning that also with regard to the construction made by the respond number 7 and 8, that in a 382 square yards, they constructed 6 floors without any valid permission. And the also given the details how the construction has been made by the respond number 7 and 8, that has been para 3 and 4 and 5 was my representation.
Yes, Siddharth.
In the 27/7/2023, we have issued them.
Once again, 20.
27/7/2023. We have issued them a notice asking for them to provide the relevant permissions and your option. No reply was given. I asked the officers to pass the required notices today. And they'll take action.
So your officers are sleeping. Sleeping or their palms are greased so much that every paper is slipping out of their hands. Then why are
The building permission, which clarity so that
27/7/2023, we are in November. What were they doing? October, August, September, October. 3 months.
I asked them to take action immediately.
You will inform this court when? What action they have initiated.
Post it after 2 weeks.
Inform this court of the action taken after having issued a notice on 27/7/2023.
Your lordship, once on 27, we only asked for it. So today I asked them to.
That's what I'm saying. You have called for record. They have not furnished. Then what are you supposed to do? Issue a notice saying that we have called for record with regard to building permission not granted. Therefore, we have to presume that no, there is no building permission. Therefore, show cause why building should not be made to ground zero. Tomorrow being ground zero, do it to ground zero tomorrow.
The permission for G+4.
G+4. 1 second. G+4. So 2 more floors additional. So you will have to you will have to bring the building in compliance with the building permission granted. That's all. Everybody was waiting. Come September, come October, some BRS will come because election year. Unfortunately, that did not happen. Thanks to the matter pending before the Honorable Supreme Court. Otherwise, the authorities, the political bosses would have issued a BRS. It's only on account of the matter being pending before the Honorable Supreme Court, they did not issue. Otherwise, they would, for purpose of votes, they would have come up with one more scheme of BRS. All these constructions have only come up because of that, in anticipation of a BRS. Friend, GP for MAUD takes notice for R1. Sri K. Siddharth Rao, Standing Council, takes notice for respondent 2 to 5, 2 to 6. Uh, yes. You have not asked for liberty. What liberty? One second. Give that. 1 second. We'll grant you liberty 1 week. This liberty, don't misuse the liberty till bench changes. Where have you asked for liberty in the letter? Urgency and better affidavit needs to be filed at the earliest. Run. We'll grant 1 week only. Counsel for petitioner has addressed the letter dated 7/11/2023 seeking permission of the court. This is that passport, no? Correction. Seeking permission of the court to withdraw the presented petition with liberty to file a fresh writ petition with better detail, with complete details. Granting liberty as sought for, the writ petition is dismissed as written. However, the liberty granted take a liberty from the court and file a writ petition after 1 year when the bench changes can't be allowed. So we know once liberty is granted, we fix a time so that everybody is will come back only before this court. Yes.
My pleasure.
1 second. పెద్ద చెరువు.
I think they have filed counter button.
You have SR number? Ma రాసుకో. Sri M. Dhananjay Reddy, learned standing counsel appearing on behalf of respondent 2 to 6 submit. that is filed a counter affidavit in the matter today USR number so and so and so. When counsel for the petitioner submit that he has also been served with a copy
Morning.
today morning itself and seeks time to go through the same and file reply if any. You want to file any reply?
May please to sir.
My lord, requesting 2 weeks time for filing counter, my lord.
Counter, what counter? 1 second. Raghavendra, what is the matter?
Is I've applied for a building permit at 774.
Hmm.
But their rejection is at page 14.
No. What ground? Survey number 74 or?
Prohibited.
74 marked fine rights.
G Abad.
My mistake. Just wait. I told you no that day. I couldn't get time to finalize.
Another matter, but I'm not coming with the same matter.
No, but the entire same survey, Maritpalli only. No? Whether they file a counter, no counter. Ultimately, whether it's a government land or a private land. You ask Mr. Ganasap, he will tell. Maritpalli, that survey number 74, you had appeared for that society, no?
Yes, ma'am.
Tulsi Society or something.
Yes.
Shanti.
Sanjivaya Cooperative and the other society.
No, you had appeared for one society, cooperative
Seva
society.
Mandal Cooperative.
Seva Mandal. That is what I'm unable to give some time because it requires considerable time to.
In fact, Pramoda was reminding me because she stays. She was reminding me, Mr. Ganu, we should one of these days.
No. In
request the
fact,
article.
you see, the thing is, it requires minimum 2 days to sit to finalize. You see, the points which I have made have only to be translated into the
The
order.
response is quite.
Not that the thing is, I have to. They have argued. Government Advocate General Office argued for nearly 20 days.
Yes.
Morning was same question. At the end of the day, same question every day from me, but no answer. Okay.
But so many citizens are awaiting that.
No. I will do that in short. This thing, but only thing is, I should not. I do not know whether I can say this. No. I wanted to take leave and complete, but
The pressure of work.
and one day if I take leave because that requires considerable time.
Yes.
I thought I will take 2 or 3 days in conjunction with the either Diwali or next week, but I was told not to take leave.
We understand, my lord, but only thing is as I said, so many people are awaiting.
No, that's true. In fact, Mr. VP Johri
Yes.
argued himself
Yes.
as a party person.
Yes.
I remember the name also.
Absolutely.
His name is one Mr. VP Johri,
Retired
Income Tax Commissioner.
Everybody's awaiting.
It will come. Maybe New Year gift. Huh?
Petition will be given the same treatment as
What? What general order?
subject to the outcome of.
No. Why you want to demolish? Ask. That's why I'm saying it would be a New Year gift. If it is a New Year gift, then make a New Year this thing. We have waited for 2 years. No, you'll get a better value. You see, in 2022, you would have sold at 4,000 rupees SFT. Today, it is 8,000 rupees SFT. Run. We'll list it after 6 weeks. Let us see in the meantime. Council appearing on, standing council appearing on.
Item 15, 16, 19, A.
You got the books, very good.
Books are ready. Right. Couldn't serve the GT revenue. But municipality is serving one of this.
With a dotted today. If I remember correctly, item 17. I directed it to be listed week after, 1 week, because it's a parted today.
Yes.
1 second, sir. My notes was there. Why 2 copies, Mr. Aryan?
No, 2 writ fictions. The
Second, 17,
that is
17911
second
and
writ fiction.
14.
Correct. Second writ fiction is a order passed by the endowment secretary.
With this, we were actually taking up on that day, 14102 of 2007.
I had read the first counter filed on 11/7/2000.
No, 1 second, let us mark the documents which I have already referred to in there.
Yes.
Order in WP, page 10. Yes, page 10 of the
Booklet.
2186. That is page 10.
Page 8, it's been marked. This booklet we will refer. But this booklet, page 8, we have referred, you read this.
In the booklet, it is page 8, sir.
Page 8. 1 second. Then you refer to order page, order in WP 7847.
Correct.
That is in page number
9.
7847.
Yes. 11. Page 11 it starts. And page 12 is there.
1 second, I will change the page number so that when we are going through the bundle, there is no confusion. Page 8, instead of page 10, it is page 8. Instead of page 13, it is page 11. Then page 20, counter affidavit in contempt. Where is, which page is that? Page 20. Counter affidavit.
Yeah, page 18.
Contempt. Page
18. Page 18.
18.
And relevant
1 second.
portion is at page 90.
No land acquisition initiated at page, this will be page 21. Sorry, page 19.
19.
19, which is the relevant portion.
Para 3 last 4 lines.
Yes.
And para 4 last 3 lines.
Okay. Yes. Then you refer to first counter affidavit filed on 11/7/2007, signed by so and so.
Irfan
305. Page number. First counter affidavit.
33.
Page
33.
33. And then you refer to para 3, 4, and 5 in this.
Correct.
Yes.
And para 6 also. Where the sale and acquisition was initiated, subsequently withdrawn.
Even then you made a submission that even if endowment land, the GHMC authorities need to take up acquisition.
Correct.
Then you refer to additional counter
Yes.
is contrary to the first counter. Where is that additional counter?
That is at page signed by
G. Shankar, page 38,
Page 38.
3A.
We stopped at that stage.
Correct.
So let us see what have you stated, what is stated in that.
Yes.
How do they get over the first counter affidavit?
Yes.
And that earlier first counter affidavit is filed by whom?
Same.
One
Chief,
second. First counter
Assistant
affidavit is
City
page
Planner.
33.
Assistant City Planner, GHMC.
No, by the same R1.
Correct. R1.
R1, here also R1, additional
R1,
counter
correct.
affidavit.
The officers are different.
No, officers may be different, but respondent is one.
Yes.
All of them have to speak in tandem. They can't. Let us see. What do they say here?
Page 2, para 3.
1 second. Page.
That will be page
1 second.
Page 39.
1 second. WP number 14102 of 2007. Refers to additional page 38. Additional counter of R1. Para?
Para 3.
Para 3.
39.
Yes. What do they say here?
I respectfully submit my predecessor has already filed a detailed counter affidavit on behalf of first husband, denying the allegations as made. Thereafter, Honorable Court was pleased to pass an interim order on 24/2/2011 directing GHMC and HMDA to provide 1 acre in the nearest possible place to Goshala, and in view of that, I am constrained to file this additional. That order of justice, that's already here.
1 second. Seeking to vacate the order. This is additional affidavit in vacate or is it in?
They termed it as in the main case itself, but they seek vacating the order dated 24/2/2011, which came to be passed thereafter. Now, para 4. I further submit that the land in question belongs to endorsement, must be endowment, but not to petitioner society. The contention of the petitioner land in question belong is false and baseless. I spoke to State Court. The respondent corporation has initiated negotiation under 146 of HMC Act to be part of land, take the part of for public purpose, that is construction of bridge at the junction, widening the Muslim. The construction of the bridge and the road development has been completed in the year 2000 and the bridge was declared open to the public on 15/7. The GHMC has constructed Goshala over an area of so and so. There is a mechanic shop and hotel adjacent to the new Goshala over an extent of 250 square yards, which is in occupation of Bihar Lal Yadav and Bhavani Mechanic Shop, who claimed to be tenants of endowment department. This respondent is not aware.
They are running a Goshala or they are running a
veterinary hospital. Veterinary hospital.
No. These tenants, because in para 5, they say that GHMC has constructed a Goshala. Goshala is meant to keep cows only.
That is not
But
there.
they can't keep humans.
This is without any basis.
No, but what is that they are trying to, what is your understanding?
They are saying there are 2 tenants who are running a mechanic shop.
No, Goshala, how can they run a mechanic shop?
I mean, they have actually overrun the property, laid the road. When we objected, some third party was brought into and all this. That's the grievance.
The respondent is outside of the details of
tenancy of the sector.
But what they
Now they inducted these people and they say they are tenants of endowment and they still say we don't know what tenancy they have. I respectfully submit that under 146 of HMC Act, the Commissioner First Respondent is competent to acquire public purpose from endowment department since the land in question belongs.
1 second.
Continuing at page 4.
Yes.
The corporation has taken part of the land in question from endowment department with its consent by initiating negotiation under 146 HMCA. Hence, the procedure followed by the first respondent for taking part of the land in question is in accordance with law, and it does not cause any prejudice to the Goshala or the petitioner, since Goshala is already constructed by GHMC and Petitioner Society is also in existence. Society is in existence. The land is taken away. The existing Goshala can be extended after evicting the tenants who are in. This is the advice they give to the society. Then coming to 7, I humbly submit that on 24 to 2000.
Now, when they have constructed a Goshala,
It's no particular. In fact, no Goshala is existing. And there was no Goshala earlier. What we were running was a veterinary hospital. And no particular is given what Goshala was constructed. No particular is given that in consent with endowment department under 146 of HMC Act, they should have find some minutes of meeting or something. I think it's fine.
yeah.
Ultimately, both counters show that the land has been taken. No acquisition proceedings have been initiated, nor any material placed before the
So
court.
no compensation paid even to endowment, nor because the endowment land also cannot be taken.
They can't take it. They are bound to.
1 second, when was this endowment land taken away?
The dispute with endowment is there since 1987.
Between you and endowment.
Correct.
Huh.
We are saying that the endowment has no right. This is a veterinary hospital. Do not come under the.
No, forget it. If the endowment is claiming that it's an endowment land,
yes.
Why I'm asking is there is a judgment of this court that any endowment land, if it is to be taken, they should approach the High Court and obtain a permission other than for irrigation purposes. That is the reason I'm asking. I do not know whether you are aware or not. There is a judgment of His Lordship Justice Nalki.
I'll check that.
His Lordship said, I have passed many orders. It's only for irrigation purposes they can acquire. Otherwise, they cannot.
I'll make a note.
Yes.
So therefore, this restriction needs to be allowed, directing them to initiate the land acquisition notification and fix the compensation.
And leave it to between you and the.
Correct. Between me and endowment department.
To fight it out, who will get it?
Here I will point out the endowment department trying to take over this petitioner society. That was challenged. That is the second petition in which this court has suspended the order of the endowment secretary. Therefore, as on today,
1 second. They are trying to take over what? The petitioner society.
Society saying that it's an endowed land, and therefore being
So they want to take over the land or the society?
Society they want to take over, saying it's a charitable institution. We'll take it.
Hmm.
That was questioned in the second petition, where the stay is up. So
is there any order for tagging both the matters?
No, at one point after one of the learned judges thought that both should be heard. I said it can't be.
Because the relief is entirely different.
Entirely different.
Why should we here?
And there is a stay there. So long as the stay operates, the petitioner society.
That is fine,
continues.
but what I am saying is, if there is no connection whatsoever, if nothing, see, today nothing turns out on the decision of this court which will have a bearing on that.
No.
Correct? So ultimately, whether GHMC is required to take steps for acquisition and pay compensation. To whom they pay is, they will put it in a, what do you call, with under section 64 or whatever it is. Make a reference and keep it.
That's why.
Only after your adjudication, who is entitled by the competent court, that whether they can take over or it is your entitled, then they will be entitled for that compensation.
That's why I submitted, since there is a stay operating in the other petition of the endowment taking over the society. In view of the stay, the petitioner continues to be the operator of the society.
See, if there is a claim, rival claim, nearly, that's why I'm saying then 64 comes into picture of the Act 30.
Correct. That's
So that has to be deposited. Then let them decide after the adjudication, they will decide.
TSHC cannot keep the compensation.
Yes. That's all, anything?
That's all in this. That's the limited order that would be required because road is late.
We'll get instructions if.
No, madam, final hearing, no instructions. If you have nothing to offer, we will close, that's all. We will record that, the standing council did not advance any arguments, that's all. Madam, matter has been being heard for last 3 weeks. You can't say that I will get instructions. You have filed counter, that's all. It's over. Make arguments. You still have 45 minutes to advance your arguments. Otherwise, we'll have to treat it. It's a 2007 matter, madam. I can't adjourn it. Sorry. I've told in the first day, when Wednesdays, final hearing matters, we'll take it up. That's all. And matter is part-out matter. You can't ask for adjournment in a part-out matter. That is the basic etiquette of the court. Make submissions.
But tomorrow it may be taken by the BC.
Madam, specific days are fixed for final hearing. Mr. Kanu, if you have seen a senior counsel coming and sitting for last 3 weeks for his matter, not 3 weeks, in fact, 4, it is 5th week. Every week he is coming because item 1 is this matter. I have finished 2004, 2005, 2006. Now we are in 2007. He is sitting for his matter. We can't accept. Please go through, tell us what is your stand.
But we have received the bundles yesterday only.
Huh?
Compilation we have received yesterday evening only, my lord.
Compilation is not needed, madam. Your counter is there. Based on your counter. This is for convenience. I have requested Mr. Hariharan to give a compilation because I was finding it difficult. It is my difficulty he has addressed, not your difficulty. Compilation is nothing new. It is all part of the record. Please, let us have 45 minutes. Let us make use of it. Because 2:30 I have vacate petitions. If you have
Only pass over, my lord.
Madam, 2:30 I have passovers. I have 2:30 vacate petitions. Not here. Please make advance submissions. Otherwise, we will take it as heard. You have no counter to offer. In which case, order will follow automatically. Now itself, I will dictate. What is your stand?
Contents of my counter affidavit.
Okay. Contents of counter affidavit reiterated. Along with counter affidavit, any material paper filed, madam, by you?
No, sir.
Only counter affidavit and make it up.
Yes.
Page 40, para 6 of my counter.
Page 40,
Para 6 of my counter affidavit.
para 5.
6 months.
What does it say, madam?
Additional counter affidavit.
Additional.
Respondent corporation is the competent authority to acquire the property for public purpose from the endowment department.
Where are you reading?
Para 6, my lord, page
Para
40.
6. You said para 5. Hmm.
Respondent corporation is the competent authority to acquire the property for public purpose.
Fine. Acquire, we are not denying, they are also not denying. Acquire, they are also saying you should acquire. But where is the compensation? रोकड़ा किधर है? रोकड़ा दो ले लो, कोई दिक्कत नहीं.
However, we have acquired from the endowment department.
Where have you made the payments? Endowment land is not to be grabbed freely. Endowment land doesn't, it is endowed to the God. So you will have to make payment to the God also. So where is Rokda? That's why I asked, where is the Rokda? When did you make payment? How much you paid? Where is the acquisition proceeding? No material is placed. Competent to acquire. Very good. That's all, madam? Okay, random. Heard Sri Hariyaman, run a senior counsel for that. So and so. No. There is no such order, Mr. Hariyaman. Linking both the matters. Rule 9, call for records, notice, interim direction, notice, interim suspension. List the matter after 3 weeks for filing counter.
It is much later informed.
వాళ్ళు ఎవరు చెప్పారు పని?
ये तो चलता रहा.
No, but the submission of Srikanth for linking the matter.
At an earlier point of time, there was.
No, in fact, Srikanth sent addressed a letter saying that there is an order. Therefore, please direct the WP 17911 to be posted along with the WP 14102.
There was an order earlier. Next time when it came, only one writ came. Therefore, we were constrained to take that.
1 second. Let us see maybe in this 14102 there is an order.
The subject is altogether different.
But unfortunately, there is an order of the Honorable Chief Justice.
That's what earlier one of the learned.
Because that letter was filed, the registry obtained orders from the Honorable Chief Justice.
Or I would suggest this may be disposed of and the other one be taken up. Next one.
See, 14102 was listed on 2/9/2014. When a submission was made, Learned Counsel for the Petitioner Society submitted that there is a dispute with regard to title of the property and it's a subject matter of challenging WP 17911, which is pending in the court. Since this court is not having roster to hear the said petition relating to endowment department, and it is appropriate to hear both the matters by a single bench, the registry is directed to Sons.
That's the first thought.
This was the submission made by the petitioner counsel.
I pointed out there is a title.
No, pointed out, but both should be heard together.
I did not request for a
This is what is recorded. That a request that both the should be heard together. And based on this order, the orders of the Chief Justice are updated. My docket done to petition. Now, what is this matter?
Yes.
GP for endowment, Regional Joint Commissioner, endowment, Assistant Commissioner, endowment. Your GPs won't come to court? Tell them once we start, there will be no adjournment.
Yes.
Yes.
This writ petition 17911 is filed against the order dated 17/7/2007.
1 second. Against order dated
17/7/2007.
17/7/2007. 1 second. Where is that page number?
Which is at page number 15.
Page 15.
It's an order passed by the Principal Secretary, Revenue Endowments,
1 second.
who by his memo dismissed the revision filed by the petitioners. This has a long history of litigation beginning from 1988.
88 is not too long. I had disposed the writ petition of 89. 88 is not too long.
Very well. We'll try to close it now. Because this order of 17/7 was passed on a remand order passed by this court in WP 2186 of 91, dated 14/6/2006. Wherein page 64, wherein this court set aside the order, remanded it back to the first respondent to hear and pass appropriate order.
Where is that order?
Page 64, sir.
Page 64. Yes. So is a consequential order to the order in WP.
Yes. WP 2186/91 was passed against an order dated 19/12/1991, passed by the government rejecting the revision petition.
Matter has been remanded in this?
Yes, sir. Kindly see at page 65. The first para states about the impugned order therein. And the second para, last 3 lines. Or the second para.
In this writ petition,
Yes.
who is this fourth respondent?
In that writ petition. That writ petition.
If you are claiming you are a veterinary hospital or this thing, how did the fourth respondent?
They somehow introduce a new person. The counter affidavit of the first respondent in the other case, the court found the Honorable Minister, MP, everyone inspected the property in the presence of President of the society. Some new person came and said, I am the society. Therefore, that person was added. This page 65, the second paragraph. The petitioner has questioned the legality and correctness of the impugned order on several grounds. I do not consider it necessary to go into the factual matrix of the case and decide the contentious issue whether a petitioner could be treated as endowment for the purpose of the AP Charitable and Hindu Religious Endowment Act 1987. Because after hearing the Learned Counsel for parties, I am convinced that the order passed by the state government is liable to be nullified on the short ground. It does not satisfy the test of speaking. The issue was that. That's why after going through so many things, the last.
Thereafter, the page 15 order is passed.
Correct.
Now, how do they, what is that they determine in this?
Before going into that order, kindly see a little of the history that goes into it. From page order 29/390. Page 50.
Five zero.
50 is the order.
216.
Yes, 50. What is there in 50?
Yes. We kindly see the order dated 29 March 91. Last paragraph. It is ordered that the demolition of the veterinary hospital of the Petitioner Society in door number so and so be and hereby stayed pending further orders on this petition. Despite that, they went ahead and demolished part of the building. Then a second writ petition came to be filed, that is at the next page. That and the order dated 22/4/91. The next page.
53.
53, page 53. The last 3 lines. While granting 2 weeks time for filing counter, the interim order directed by this court on 29/3.
Meanwhile, at the 52, that is the difference between the
Where are you reading?
22nd day or 52.
52. That is the order dated
In
22/4/91 in
WPMP.
WPMP
Page 51 at 52.
Correct. They were trying to alter the property. Therefore, this new MPs were fired. And this is the order of the court at the page 52. The last 3 lines of that order. Interim order directed by this court on 29/3/91. which I already showed, and made in WP 2186 of 91 shall be continued pending further orders in this portion. Then
In that, against GHMC.
Then despite that, THMC was interfering. Therefore, another writ petition came to be filed, that is WP 6282 of 91. That is at page 53. And in that,
53 7847.
that is MP number. MP number 25th April 91.
Where is the WP number?
Below the name of the petitioner. Petitioner in WP 6282 of 91. Kindly see the prayer. Please to direct the respondents herein to provide necessary police aid for restoration of status quo ante as on 29/3/91 by taking necessary steps by removing the unauthorized construction and also initiate necessary action under provisions of HMC Act 1955 and rules pending so and so. It is ordered notice so and so. It is further ordered that the respondents herein and be directed to provide necessary police aid for restoration of status quo ante as on 29/3/91 by taking necessary steps, removing the unauthorized construction and also initiate necessary action under provisions of the HMC Act 1955. This was the order passed.
That's an interim order.
It's an interim order. Thereafter, the contempt was filed. In the contempt, that is the counter affidavit which I read to the court.
61.
Page 61. Yes. Page 61. The counter affidavit was filed by the commissioner
Counter affidavit in contempt.
in CC 1066.
61.
Yes.
Which paragraph?
Yes, this is, there are three.
Yes.
There are three. It's true respondent corporation has constructed a new bridge parallel to existing bridge to ease traffic. But the allegation veterinary hospital building belonging to petitioner has been demolished in toto and a road leading from the new built bridge adjoining old Muslim junk is laid on the property of petitioner is now relevant to submit. Honorable Court was pleased to pass an order directing to provide necessary police aid for restoring status quo order as on 29/3/91 by taking necessary steps by removing unauthorized construction and initiate necessary action. So and so. I submit as the building in question was constructed unauthorizedly without permission from the corporation. The respondent corporation.
One small doubt.
Yes.
Looks like this is a title dispute between the endowment department and the petitioner society.
Endowment department do not claim it as a title to the property. As a endowed property, they want to exercise.
Whatever it is. Somebody would
It will
have,
not be a title.
no. Somebody would have endowed it.
Correct.
So they are trying to protect it by for the benefit of the person who endowed it in favor of the God or whatever it is.
We are the persons in management.
But the thing is today, can a title dispute of this nature can be gone into in a 226 jurisdiction?
The issue then would be, can the government claim for itself title unilaterally?
That's
Without
what I'm
that
saying.
being a
You see, why I'm asking this question is, if, assume for a moment, if you were to challenge the action of the endowment department claiming that nobody has endowed it. In fact, if at all, anybody has endowed it, it is in our favor.
they don't say.
Or let us say, if, they don't say, but if you.
I'll read that counter.
What
They
I'm
don't
saying
say
is,
it's not endowed.
why I'm saying that is, prima facie, to me, it appears to be a title dispute between the government and your, whereupon only on what basis and strength the endowment department is laying, claim to this land as being endowed would have to be gone into.
It
By
has been-
looking in the documents, that
has-
cannot be gone into prima facie. I am of the view that 226 does not provide for it.
Now the order passed by the authority.
The proper course would have been to, that's what I'm saying, the proper course would have been to approach the competent civil court.
So it's not a civil dispute. It's not a
No,
civil
let us see.
dispute where the government.
Prima
claims
facie, I am of the view, I am making it very clear, maybe
it's
you will
not
have
the
to.
government's claim that it is government property.
No, it's an endowed property. See, today endowment department is a protector of the endowed property.
That's all. To that extent.
So today, who has endowed it? If it is you are saying it is your property,
Correct.
you have to establish your claim.
The claim of the department, endowment.
No, first of all, today you are claiming,
They don't dispute my title. What they say is, way back in 1953, he then secretary of the society gave it for endowment department. That is, got it registered under section 43 of the act, old act.
No, gave it
And
to
that-
endowment.
Not gave it in endowment, got it registered with the endowment.
Secretary got it registered.
Yes.
So it's a private endowment. One second.
The public purpose protecting.
Got it registered.
Purpose is
One second. Got it registered as endowment.
Way back
But-
in 1953, that is the content. That is in dispute.
But therefore it's a private endowment.
It's a private endowment for public purpose.
Private endowment.
This was established way back in 1926. And these and this
government,
was the pattern of this society.
Cannot claim as endowment property.
So it's not a title dispute between government and petitioner.
Okay. Yes.
That's why the other petition I argued, even if it is an endowed property, the only course for municipality
No,
is
that
So-
is separate. That's over.
now
Yes.
in this case also, even if it is an endowed property, as they claim, which is disputed, the pensioner society is in management of. The endowment department cannot over.
No, has this document of 1953 seen the light of the day?
They discuss it in the order, but I didn't find it there.
Now let us see their document, this counter. What do they say in, with regard to this endowment?
No, and if the court can spare some time and read the para 3 to 5 of the affidavit, how the petitioner claims and how the dispute has arisen.
No, let us see the counter. Let us see the counter of the respondents.
In this writ, sir,
With regard to the endowment creation and other things, what do they say? Copy of counter affidavit filed.
page 84.
Page 80.
Endowments.
Yes, let us see what do they say in the 80.
Yes.
Para 4.
Para 4, sir, page 87.
Page 487. Yes.
87 paragraph. Before adverting to Parave's reply, I submit the Petitioner Society for Prevention of Cruelty, situated at Muslim Jungle, Hyderabad, is a charitable institution registered under provisions of the Hyderabad Endowment Regulation 1348 listly, wide Muntakar number so and so. It is submitted subject society is located in premises number so and so Muslim. It is categorically stated after the commencement of the Telangana State Charitable and Religious Institutions 30/8/7 falls within the administrative jurisdiction of the Assistant Commissioner Endowment. Yes, at para 5 at page 18.
Yes.
In reply to governments raised in para 3, all the governments other than those who be expressly admitted are been. It is submitted the Petitioner Society was registered under the provisions of the Hyderabad Endowment Regulation 1348 at the behest of the then Honorary Secretary. It is submitted the Petitioner Society is a self-statutory which has not formed under the statutory provisions of the Prevention of Cruelty to Animals Act 1960 or its predecessor act. It is submitted the Petitioner Society used to get donations from public and is at present a defunct society. It is submitted the Petitioner Society established a Goshala with an attached veterinary hospital to cater to the deceased and sick animal. It is categorically stated that Regulation 11 of Chapter 4 of the Hyderabad Endowment Regulation 1348 clearly stated that buildings of public utility such as hospital, Goshala, etc. are to be treated as endowed buildings property. It is also submitted that catering to the needs of deceased and sick animals fall within the scope of medical relief under Section 25C and D of the Endowment Act of 30/8/7. That is the crux of the matter. What they say is if you are treating animals, it should be treated as medical relief to the animals. Medical relief to the animals is also a charitable objective. That is how they want to take over the control and administration. That is what is subjected. That's why the learned chief judge in the order of remand said he has not addressed that issue and remanded it. The remand order again has reiterated the same thing, and that's what is in question. Hence, there is no iota of doubt. Subject institution fall within the control of endowment. Further, it is submitted that mere non-exercise of power by endowment department in the past will not exclude the subject institution from the control of endowment. It is learned that the Petitioner Society had even applied to the municipal authorities for obtaining permission for constructing commercial complex in the premise of institution, which is nothing but a clear-cut violation of the object for which institution is founded. As the matter stood as then Commissioner, Assistant Commissioner, Endowment Department in cities took proactive steps to constitute a non-hereditary board of trustees to head the administration and management of the subject institution, wide proceeding number 1712/88. That was.
Let us see the statement of endowment.
Statement.
Yes, sir.
Page.
Page 96.
Muslimganj will water bottle fees 35,000 door number.
Door number is there. Hospital with cattle and dog wards, waters in the staff and water trough for animals of the trust. Income charitable.
Drink.
Animals to possible to drink. Then boundaries are mentioned. Then the secretary's name is mentioned. Devrao Damodar Jatkar. Work of and work of welfare of an object.
Is there under the.
This was in fact recorded prior to the Endowment Act of.
Correct, because that was in 1957.
Correct.
Before the state was formed, it was Hyderabad state.
There were regulations governed it. Fortunately, despite the efforts, I couldn't get that copy. And the new act 30/8/7.
No, the 1987 act.
Yes.
how does it treat an endowment, existing an endowment? What is the treatment given under this act upon the act coming into force?
I think there is one provision that I will show. Within so and so time, they have to register as a K.
After this act comes into being, there is a provision to register this endowments. I just point out that. Section 43.
Yes.
Registration.
Yes.
43. The trustee or other person in charge of the management of every charitable or religious institution or endowment shall, in case of an institution or endowment in existence at the commencement of this act, within 90 days of such commencement, and in the case of an institution or endowment found after such commencement, within 90 days of such founding, make an application for registration to the Assistant Commissioner within whose subdivision such institution or endowment is situated, provided the Assistant Commissioner may for sufficient cause extend the time. When any endowment is situated in the subdivision or two or so, that may not be required. Then B, on receipt of such application, Assistant Commissioner concerned shall refer to the matter to the Commissioner, who will decide as to which Commissioner shall register the endowment. And 3, notwithstanding anything contained in subsection, no application for registration shall be necessary in case of an institution or endowment which has duly registered and entered in the book of endowment before the commencement of this act under AP Charitable and Hindu Religious Endowment Act 1966. When the procedure for recording this one is
On 5/5.
So if a institution was under AP Charitable and Hindu Religious Institution Endowment Act 1966,
if it was there in 66 Act, then within 90 days of coming into of this Act, he will make an application.
no, not required.
That's what I'm saying. He will re-register it. Otherwise, if it's a new institution, he will make an application.
No application is required for under
See,
60.
if the institution is registered under 1966 Act,
Correct.
no registration is required. If it is only a institution which was not part of under the 1966 Act, within 90 days, it should be registered under subsection 1.
We were not part of 66 Act.
No, but that's what I'm saying. How does the 66 Act deal with the existing endowments which were there?
Perhaps not. I have to go back to the old.
Because similar provision would have also would have existed under the 66 Act, making it compulsory that an existing endowment should be registered.
Subject to correction, I don't think there was an identical clause in the 66 Act.
And what would be the effect of non-registration? So you will not have the protection of under the Endowment Act.
But our principal contention was treatment of to the animals. It's not covered by this. That is on that principle we can.
No, but one second.
Yes.
You do not dispute the fact that your predecessor in office and in 1953 or whatever date
Yes.
has created an endowment
Correct.
with a particular object.
No, he
Will it be open for you today?
I'm sorry, he didn't create the endowment.
Hmm.
Endowment was created in 1926.
Hmm.
In 53, the said secretary allegedly has got it registered.
It's a that you see, once it is registered as an endowment under the endowment, whatever that firstly, will it be open for you to say that it does not apply to me?
That registration itself is being disputed. That
After-
registration.
No, no, 1953 being disputed in 1991.
It all came out only in 88 when they
No,
sought to
but
take over.
one second, how do you,
And they
one second,
wanted to abolish this.
1953, when there is a muntakab and a statement of endowment is registered, is it open for you to dispute that? You may claim that it's a private endowment, but how can you dispute it?
That claim is always there. It's a private endowment for the purpose of welfare of animals. That's why we said we are governed by the
See,
prevention of
page
cruelty.
99, which is filed,
Yes.
shows endowment being created.
Yes.
99 and 100 are relevant, sir.
They use a statement pursuant to the muntakab which they have.
That's what I'm saying.
Correct.
So 1953 or 55, whichever date,
Yes.
99, 100 shows creation of an endowment. Maybe a private endowment, but it will not be open for you to now contend to the contra that there is no endowment at all.
What I'm trying to say is 87 Act will not still govern us.
No, no,
Is
that's
the contention that is raised.
87 Act may not govern. There are two exceptions to that. One, 66 Act, does it provide for a similar provision making it compulsory that an endowment should be registered, which is in existence
That,
on the date of 66 Act coming into force?
that I have to check.
Thereafter, if it makes compulsory or if it is treated that under the old Act, whatever is registered is automatically treated as continued, then it continues. Therefore, under 87 also, you are not required to take registration.
Registration.
So it flows continuity.
That's right.
That the continuity exists.
Regards that registration, what is sought to be urged is that caring for animals is not a activity that will be governed by this act, and the department will not be able to control the
But you
management.
yourself, see, that is what I am saying.
If I have, I'll go to the next extent, even if I have wrongly registered it. If the
Not open
authorities
for you after 40 years.
No, they are governed by the act. They are governed by
No,
the
you see, rightly,
And
wrongly,
from 59 onward, they never exercise 54 onward, they never exercise any control over this problem.
that's what I'm saying. You would have created a private endowment. There are
It's a
private
private
endowments.
So,
I'll tell you, in Narayanguda,
yes,
behind opposite, you have this stamps registration. Opposite that complex, behind that building, there is a private endowment, a temple.
yes, sir.
Private endowment. It's a private endowment.
But public, when public are coming and going, it's for public purposes. The contention
Today,
is
that entire endowment, their family members or whoever will not be able to deal with it as it's their private property.
correct.
So it is only meant, that is why the property is continued. So as an endowment. So whatever income generated or received will have to be spread only for that
I'm
endowment.
also not saying the income out of it will be taken away by the members or anyone. What we are trying to say is welfare of animal is outside the scope of this.
The
That's the
you see
point
that
needs to be considered.
you see,
That's the point that
unfortunately,
needs to be-
Authenticated copy of translation is not filed.
That's why I said.
Urdu translation is not filed, only we'll get it read through somebody who knows Urdu.
That is filed with the department nowadays.
No, because it's filed by the department.
No, that is true. That's what I'm saying. The
Translation is no issue.
Muntakhab, which is at page 100. 1957, 1959 is the date of Muntakhab. The objects for which the endowment is created is mentioned at page 100, last 1 and 2.
Veterinary hospital.
No, not that. At the bottom in Urdu, if you see from right to left, 1, 2, the objects for which the Muntakhab is this is created is mentioned 1, 2, 3, 4, 5, 6, 7.
Yes. Yeah.
There are 7 this thing in the in
That is
Urdu.
noted in page 101 also.
101. Let us see.
Veterinary hospital, institution with the locality and village. Veterinary hospital.
Together with cattle quarters. and
Cattle
dog
quarters, dog watch
staff,
staff
of water
trucks for the animals and public under management of Society for Prevention of Cruelty to Animals.
You yourself have created for this thing, prevention of cruelty. You wanted to treat it.
There is no doubt about it. They tried to say in the counters and all Goshala. There was no Goshala. It's a veterinary hospital. As part of the activity of the police under the.
No, but you created this as an endowment. Maybe in 1957, 59.
Correct.
Under the then endowment act, whichever covered.
Yes.
You wanted to create so that it will not come within the purview of tax or whatever it is, for whatever purpose. You wanted a specific this thing. So today, is it open for you to wriggle out of that and say,
provide to the animals' welfare? Now the question that's posed to.
What is cattle quarters?
Cattle quarters are sheds. Sheds.
Sheds where cattle are.
As veterinary hospital, I am running a hospital. Some of the cattle will be treated for 2-3 days. So we create some sheds.
It is not, they simply said for providing treatment or anything. In fact, name of the endowment is Society for Prevention of Cruelty to Animals.
Correct.
So if it is a hospital, you would not have got it under that. We'll consider. Yes. The issue is whether a private, what is the control or what the endowment authority can do if it is a private endowment.
As I pointed out, the dispute started with the order dated 8/3/1988 passed by the Endowment Commission. That is at page 24.
Yes.
That was the subject matter of the revision and the writ 2186, which got remanded. Page 24.
There are 25, 26 and 27 are the crucial in the impugned order. Page 22 and 23.
In the impugned order. Yeah. But go back to see the genesis of the dispute, because from this order it was further remanded.
Please read para 24. The opening sentence of Sri Jatkar, the Honorary Secretary's letter, is clearly a statement of the true character of the institution. The Society for the Prevention of Cruelty to Animals is a public charitable institution.
for welfare of animals.
So it's a public charity. Under Public Charitable Institutions Act, it has been registered.
For the welfare of animals, they can't seize the property is our country. That's the issue the court has fixed.
The underlying idea is that it is a public utility running on charitable lines as distinct from a private institution run with a profit motive.
Reports of the then secretary and one society member clearly show they were not collecting any fee for treatment of animals even in 1953. The rationale advance now for deleting hold of endowment department that the act deals only with Hindu charity does not seem to be correct. The title is so and so, in which pertinent to see the act applies under 5D, making it abundantly clear, not being an object of an exclusively religious.
See, the question, the mute question that calls for consideration is a public charitable institution which was registered. Can it be brought under the ambit of Hindu religion by saying by classifying or attributing the religion to the animals? Can we call a cow a Hindu cow, or can we call a cow as a Sikh cow, or can we call a cow as a different cow? That is the issue. That is what is to be addressed.
Yes. That
Merely because a cow is reared and by a non-Hindu, that does not become a non-Hindu cow, or does not become cease to exist as a cow.
that exactly is the argument.
Over.
So I need to read the provisions of the act and the judgments.
We will see if after 2:30 the interlocutory applications, vacate petitions are this thing. If further time is there, we will take it up. Otherwise, matter will continue. No, that's why I'm saying 2:30. I will take up only the vacate petitions. After that, if the time permits, we will take up the matter. Otherwise, matter will spill over to next week.
For any reason I am unable to reach, kindly account.
You are coming to this court for the first time. So I am telling you, we'll take up, there is a notice board. We have identified and circulated the old matter only Wednesday. So today, if he is unable to complete, matter will come next Wednesday. You will have to make argument. The other matter, you are not there. We have recorded, it is heard and orders reserved. You have not filed counter nor advanced any arguments in that matter. Madam, old matters, I've been very strict that we have listed, we will hear. That's all. Enough 14 years, 15 years matters have been pending. No further time will be granted.
Right.
So PP provides decision data.
Item 2.1. What have you done? Which?
What is the sentence?
What does it say?
Today we're not pressing. Today we're not pressing. This is some short time.
No, what is the equivalent provision? You refer to Municipalities Act, no? What is the equivalent provision in the GHMC Act?
Section 440. Alternatives to be given in the building or building person shall report without taking permission of the commissioner or and be confined in terms of such provision. Order. Sorry, foundation or order to be made in an existing building personally constructed or order for the corporate use of unit or asking for use of program warehouse workshop workplace factory stability or motor damages.
Yes. This is a mother and brother's fight, no? You are one of the.
Right.
The side maps number 3 and 4 here.
Page number?
The 3 and 4 here now. The first floor. The said construction is going above the first floor and number 3 just above my head here. Because of the construction, the person has made holes to raise the pillar, this one here. Construction, and from that holes, the water is getting leaked because of the yesterday's rain also. The photograph is like for 27. He made holes to withhold that this thing and the water is leaking from
No, once he puts the roof, it doesn't leak. No, once he puts a roof, it doesn't leak. That will protect. That will protect. Yes, madam, what are your instructions? No excuse, madam. Either they should say that we are closing the GHMC office for next 1 month. Put a tala, give the key to us. One second. When did they give representation? 30? 31/10. 2023. That is the only first representation, not before. Not any time before. No, you walked in. Your walking in is not sufficient. So the letter is served on 1/11. You have not given 1/11. You sent it by post. It was delivered on 1/11. Where is that page number? No, but is 7 days according to you sufficient time? No, I'm asking you. Is it sufficient time?
Because if they don't take action, the water keeps leaking and it will.
Is it a rainy season, monsoon season?
Yes.
What? I didn't. At least I was here till 9 o'clock. It didn't rain here. There was. It was droplets. It was droplets here. That's all.
At least it doesn't take my translation.
When will you inform madam? Next week. When the GP for MAUD takes notice for one.
This matter appear the petitioner and reduce the case, but for fact, that recently Arthur has filed the counter and vacate state. I need little time to file my claim. All others have.
When did they file vacate?
1999.
99 is not recent. What is this?
That's 99.
One second, we'll tell you what date it is for. 1.5 months. Today we are on 8th, sir. 8th November.
1 week's time.
6 weeks are over. See, the problem I will tell you. We list vacate petitions on a specific date. As of now, my calendar up to December is full.
Oh.
Diary and tail book here.
I believe.
He's taking today. He wants to take time because at one point I'll not press that one point, my lord. So let him not. Because my worry is that I'm cognizant of your lordship's calendar. I don't want to lose the date to this.
As of now, 5 cases are already over. My Royal Legend members, they are empty. Updated, it should be updated. You see, up to 2012, my calendar is Wednesdays are already blocked.
Which is what on a public road, he has built a wall, and then he wants. So lordship, other than my vacate, let him argue the other vacates. I'll only support their point, madam. So let him. I'll not press my point.
Mr. Counsel, vacate is filed. We can't keep it pending. You see, there are 2 vacate petitions. IA 3 of 2021. Then, one second, IA 3 of 2021, we'll take it up because. No, 1 second. Then IA 1 of 2023 is filed. That's also vacate petition. IA 2 of 2023 is filed. 3 vacate petitions are filed. Please, we are here. Can't help it. I can't help it now. Otherwise, we'll have to vacate the order. Please understand that with great difficulty, we are listing matters. Sir, 2021 vacate petition, you can't be saying that I will file a vacate reply. We'll take it. We'll take up that only. We'll take up that only. Wherever pleadings are complete, we'll take up that matter. Please proceed. Which one? IA?
2021 vacate I filed.
2020. You proceed.
One substance of the cases like this.
1 second, Siddharth. What is your IS Siddharth?
IA 3 of 2021. Vacate petition I filed. IA 3 of 2021.
Yes.
Common substance is Manals. But basic community permission for start Manals. And in lieu of the development charges, some land was asked to be gifted to HMD. The developer has gifted the 3% of the land out of the layout to HMDA. HMDA later on used that land for auctioning the plots, and HMDA has utilized that space that was gifted to HMDA for auctioning and sold the plots to several people. Now, after that, plots.
No, what was which provision authorizes you to take the land in that fashion?
There's a group housing.
Please show that provision.
Page 37.
Page 37 of
The red papers. The learned friend is lying.
1 second. Geo 526.
The 39 page.
39. 1 second. Now this is part of the Geo only, no?
Yes.
Refers to Geo 526. Yes.
There's a scheme, group housing scheme in Lordship project.
Hmm.
In respect of group housing projects, which includes apartments, blocks, row houses, cluster, mixed houses, gated developments, and residential units in sites 4,000 square meters and above. Out of the total site area, the developer shall set apart 3% of land and give to Hyderabad Urban Development Authority free of cost of capitalization towards provisions of master plan facilities. This condition shall apply only to sites located outside GHMC limits. The owner or developer has the option of paying 1.5 times the basic value of such land of CUDA in lieu of such land. So instead of 1.5 times, he has chosen to gift it. Now let's go to his gift deed once. Page 70. Let's go to page 70. Part of the gift deed, which I want to put 75 lots. Unnumbered para 1, 2, 3, 4, 5. Whereas the donors hereby gives 3% of the layout. That's kindly underline layout to an extent of 4485 in the layout which is shown in schedule of property in red color as per the layout so and so out of so and so. Now this 3% of land is very much part of the layout and the donor says HMDA is absolute owner of the property. HMDA for the purpose of auction has auction.
1 second. The permission is taken as a layout or as a what is the
community layout. They have
no, there is one. There are layout is one.
Yes.
And the houses are constructed by them and sold as a group housing. So how does this 12 group housing scheme come into picture?
Because the layout permission that is sought is for gated community.
Correct. See, the 12 group housing scheme is where they construct houses in the same pattern.
Yes, they have done so.
That may be by way of an agreement after developing a layout.
Yes.
You see, there are two ways. If you see up to 2008 or 12, there was no concept of this gated community under your Geo 86 also. Correct? So what they did, they had group this layout where the layout is developed, permission is taken for a layout, but by entering into agreement with the plot owners, they have agreed that they will all construct in order to maintain uniformity and all, they will all construct a house similar or the pattern which are approved as per the agreement, and then they will maintain, they will not construct beyond 2 floors. All that is done. Otherwise, tomorrow in a general layout is that 4 plot owners together come together 300, they can give it to apartment. So by virtue of a private agreement, what the developer has done is that he has ensured that all the parties, whoever are purchasing land, plot of land will abide by the terms and conditions of the agreement. So it's a contract. It's a contractual obligation which the parties have agreed to abide by. But your layout sanction is open layout. That's what I'm saying. Gated community is one with the houses. The second is only open plot. This rule 12 applies in respect of the layout with construction. Row houses. Look at the rule 12, regulation 12. This I think is amendment to GO 86. 288 and amend. See, originally 86 and 288 GO was there. Page 39. 1 second. Huh? GO?
Page 39.
Huh.
Page. Regulation 8B.
1 second. 8B. Yes.
Minimum area and other requirements for the layout development.
Hmm.
B.
Hmm.
From the developable area, 5% of area should be given to Hyderabad, so and so free of cost for capitalization to the master plan.
Hmm.
So this condition is there, man.
Hmm.
But Lakshmi, as per the gift deed,
Hmm.
they have gifted some X% of the land in lieu of the development charges that
Hmm.
are going to be levied.
No, 1 second. Now let us see for the what purpose they have gifted.
Yes, 75.
Hmm.
Married.
Yes.
Whereas the donors are hereby gives 3% of layout to an extent of so and so, and the layout wherein shows schedule of property in red color as per the layout out of the total layout of so and so. The donor has accepted to give an extent in the above as per the GO exclusively to the donor, and the donor had today hereby accept the same.
Hmm.
That in persons of the said intention in consideration of legal obligation which the said donors have for said donor, the donor put out of their own free will and consent sound mind without any coercion so and so unto donate or the piece of land. Sorry. Next. Next, the donor hereby declares that the property gifted away here is free from all encumbrances. Next, the donor hereby declares that he has become the absolute owner of the open spaces and is what put in possession of the same altogether with affordance and shall enjoy the fruits of the land acquired therein for any purpose as per Dhoni's choice and also discretion of Dhoni, for which is acquired to give deed from the donor to the donor.
So discretion of the donee.
As per GO 31/7/2008.
Donee choice and also discretion of the
Yes.
donee for which it is acquired.
That is made very clear.
Hmm.
The scheduled land is not attracted by AP land reforms. Next POT Act.
Yes.
So as per this gift deed balance, HMDA has become the absolute owner of this piece of land and they can use it for any purpose. In view of that balance, they have auctioned the property and we have sold it to some people. They have executed the sale deed and they are in the position right.
1 second. No, so is it in the middle of the layout or it is by the side?
That is my learned friend.
No. 1 second. Do you permit construction of a compound wall excluding that or this forms part of the layout?
That is exactly what the question before the court. Because they have raised compound wall, we have given a notice to remove to the developer. But the association is before the court without a.
No, 1 second. Today, let's say this 5% or 3% is this side. Now, can I construct 1 second? This is there a condition that this shall also form part of the layout or it can be exclusive so that I can keep it a separate? I'll tell you one thing. Today it's a residential layout. What is the permission is residential layout. Now let us say you have sold it to a commercial. Let us say you have sold it to some multiplex. And if can that multiplex be part of the residential layout? That means there has to be a separation.
My lordship, this land was for residential zones in the layout also.
No, that
There
I'm
was a
only just trying to give a hypothetical example. Today, that's why I asked you, is it by the side or in the middle?
By the side, lordship.
So by the side. No, that's what I'm saying. I'll take it. When you Siddharth is saying, I'll accept it. That's correct. So by the side. Now today, by the side, you have a right to auction it, capitalize it. You have capitalized it by selling it to somebody who wants to construct a
individual plot orders.
That is true. But today, I have constituted a community with people like-minded people. I may put 100 conditions, I may have certain clubhouse. Those people, these people to whom you have sold the plot would not be entitled for the benefits of the community.
Would be entitled.
Where do you say that? Merely because I have given the land to you, how will they be entitled to the benefits of the community?
Lordship, they that
You
don't.
see, I'll put it this way. I have given you land, delineated the land and given to you. You are entitled to do what you want. But how can you come and again, what is the purpose of me giving the land to you? You can capitalize it. How can you come and intervene in my this thing?
I'm only saying with regard to access, Maharaj. And the question, the urge of what
That is what I'm saying. Today, if it is a separate property and I should be allowed to construct a wall delineating my property.
He is not permitted to construct a wall blocking the way. That is my.
Blocking the way. That's what I'm saying. Today, if there is a road, you say this is the road. See that. I have given you 3% or 5% from this side. I construct a compound wall. You can have access from this or this, whichever way. But you cannot say I will still continue to go through your premises so that the purpose of my having a separate gated community gets defeated. Sorry. This is the only case. Then run. Over. Vacate petition is over. Half an hour.
I only take one.
Cheppu.
Page 103. Page 104.
104.
Lordship will see page 1. It is clearly reservation of 3% total area to be given free of.
Where are you? Page 104 is some drawing.
Page 104 is a map. Map.
Which map?
104, Maharaj.
Same thing.
Your Lordship can see the lines in the bottom. It says reservation of 3% of total free of cost to Buddha for disposal for residential or commercial use. And there's a
this is the reason I asked you. Tomorrow I construct a multiplex here. You still say that I should have access from your community gate. Can't be accepted. Which will defeat the purpose of my creating a gated community.
But they themselves have donated 3% of their own layout.
That is true. That is true. You can, 1 second.
As long as it's gifted in existence.
They are not denying to, they can't go back on the land that is gifted. But your claim, no, 1 second. Your claim that you should allow to come through their community gate. I'll put a gate. I'll put some RFID stickers to my vehicle. Community people, anybody coming, automatically they will have access. Others cannot have access. The purpose of, otherwise, what is the point in developing a gated community when anybody and everybody comes into community without any security? Purpose is defeated. అంతే కదా ఇంకేం లేదు కదా
I only try to.
ఇంకేం లేదు ఓవర్ టైం.
I only say one thing. When the layout developer himself has donated,
he is not disputing. They are not disputing.
That is the substance of the.
You see that land.
I don't think the donor here will declare the donor has become the absolute owner of the open spaces. He was put in position of the same together.
Shows one clause that they will continue to use the same facilities provided under the community by the developer. Show the show the clause. Show the clause in the agreement. 77, yes.
Donor hereby declares donor here has become the absolute owner of the open space and he was put in position same together with abundance and shall enjoy the fruits of the land acquired therein for any purpose as per donor's choice and also discretion of donor for which.
All that is fine. Today you may say commercial, tomorrow you may say dance bar, anything. No, we are not bothered. But the thing is saying that you should, you will continue to have access from this property. Only that is the. Siddharth, understood. Definitely record your application. Your here without recording your contentions, what will we decide? Yes, over.
Just in support of, but on a different point altogether. I am the donor in this case. I am representing the donor, the person who has gifted. So instead of paying developmental fee, HMDA said you either pay developmental fee or gift the land. I have gifted the land. Now, after gifting the land, I build a wall elsewhere. I try to build a wall.
His case or?
I'm supporting my case because HMDA is now saying that I can't, some 10 plots now they're holding back the final layout permission because a wall has been built by the society. Earlier, they asked me to demolish the wall. They said, once you have gifted the land, you have to demolish the wall on the public road. I demolished the wall. Now the association has come up and built a wall on that. I understood your lordship's point that giving access, that I think it's a fair. All I'm telling my lord is that they have built a wall on the public road. I understand that stopping access. What all of impugn order today.
Vivek, I'll put it this way. Excluding the area which is gifted in favor of HMDA, the property should be a gated community, bounded by a wall, then only it can be called as a gated community.
I understand. I agree with that one. I agree with that. Today, the impugn order is that they are building a wall on the public road, on the gifted land.
Who is building?
The society.
You see, I'll put it this way. Today, you have developed the layout. You have given some part of the land to HMDA.
HMDA. That's a public road.
No. So they are the absolute owner of that land.
I can't touch that land.
Rest of the land is to be considered as a community and it is to be secured by a compound wall, fencing, whatever it is. That's all. End of the matter.
That's the end of the matter. Whether they have done that, whether entitled that, that's it. Today the issue is not on the rest, as the law says. Today the issue is on the donated land.
No, we are not concerned. Donated, nobody has any title.
That's exactly. Please see the impugn order. I'm completely. The impugn order in this case is that they are building a wall on the donated land, not on this one.
No donation. Donated land is donated land.
Yeah, donated. That's what I'm saying. So today HMD is saying is that
once a gift is
none.
No right.
I have no right. That's what, so today the impugn order in this case, an interim order which we are trying to vacate is that it's for the donated land, not the rest of the land. On the donated land, they have built a wall association. Kindly see the.
No. First of all, 1 second. What right association has got to claim? Because you are the developer.
I'm the owner, my lord. Unfortunate owner, I would say. Unfortunate owner stuck between the two.
You are the owner.
Developer is. One second. Yeah, developer is another council.
I've seen enough of this gated community litigation. I will tell you.
Yes, sir.
Starting from Hill County to this thing, I know the entire litigation in this Hyderabad. How tax planning is also done, I will tell you. All these agreements have come only as a tax planning measure to avoid the sales tax on the total value. That's why I'm telling you, I will tell you entire thing. Now, Mr. Vivek, tell
yes,
me one thing.
yes, madam.
The land which you have gifted
to the in lieu of development fee.
So that land should be excluded. Let us say you have 2 acres of land.
Yes, ma'am.
So that is about 8,840 square yards or whatever it is, 4240 into 2. So 5% you have gifted. I'm just giving a hypothetical example. So let us say you have given them 500 square yards. That 500, excluding that 500 square yards, rest of the property is to be secure.
Yes, ma'am. Now, under the regulations, ma'am, I completely follow. Now, the regulations, what they say, in the rest of the property, this is a different issue. My first issue is for the donated land, which I think I'm hearing your lordships say the same thing, that for the donated land, neither I have a right nor anybody has a right, it belongs to HMD. The impugn order in this case.
No, but once again, when are you required to execute the gift deed under the terms?
At the beginning itself, and I've already executed it. He's read it out as
asking. I will tell you.
At the time, sorry.
Asking is, I will tell you what is the purpose of that.
Probably, the commercial object, and let's be not. I'll be upfront about it.
Tell you is, Vivek, so that you execute a gift deed, excluding that part, so that you can take up the development of the layout as per your design and plan. So that is why I'm saying Mr. Siddharth cannot come and say, I will become a kebab mein haddi.
Yeah, the only thing, is that on page 20, now your lordship will, this is the answer to your lordship question. Lordship may take my vacate. This is on the rest of the land. The HMDA regulations say that for the rest of the land, the roads and this thing, even that has to be maintained by HMDA. I understood what is following from your lordship, that a gated community should be like a oasis, a private enclave for themselves. I was surprised to see this, Marat, but kindly see the regulation. The regulations say the local authority shall ensure that the roads and open spaces which are within the local authority thing. So even that also they have to maintain them. But remember, today we are not on that one. Rest, my lord, lordship can hear at the time of the main writ petition. Today, donated land, let it be. As the lordship said, nobody can touch donated land.
I'll tell you one thing. Now, once the after gifting, let's say 500 square yards or 1000 square yards to be on a rounded this thing. Let us assume, I'm only giving a hypothetical example. 1000 yards you have gifted.
It became a public road.
Become property of the
HMDA.
So the remaining 9,000, I'm just taking a round figure.
9,000.
1,000. 9,000 is your exclusive this thing, for which you will submit a tentative layout.
Yes, ma'am.
So after executing a gift deed for 1000 square yards, you will release the tentative layout in favor of the developer. And based on the tentative layout, he will leave the roads, power, water, everything, and make it into plots and sell it.
Yes.
Correct? Therefore, the persons and the open areas within the layout, even there also, even within that 9,000 square yards, some open spaces have to be left, 10% or whatever it is for park and other. All those also vest with the local authority. But that does not become the property of the local authority. It is meant for utilization and enjoyment of the people in the layout. Correct? So therefore, the people who purchase plot can only purchase the plot of land for which a sale deed is executed by the developer or the landowner. That's all. Merely because all the plot owners are formed into an association, they cannot say the open land, that 5% or 10% belongs to us. It belongs to local authority, but meant for enjoyment of the lower residents. Okay. Now, so far as that is concerned, internal roads, everything, I'll put it this way, Siddharth. If roads, everything will best with the local authority and they say, we will open it to the neighboring this thing, then what is the concept of gated community? It becomes a public road as good as staying in a Madina road.
Today, the writ petition, in your example, today the writ order and the writ petition relates to the present example, 9, 10.
1000, I am very clear. Nobody can claim it is HMDS property.
No, that's exactly what can I say the impugn order in the writ petition? The impugn order in the writ petition. Let's take the order which we go. At page 150, Manoj.
Impugn order is at 150.
Yeah, of the writ petition. But we agree with what fell from your lot. We're only confining to the gifted land only, Manoj. That's it. We're not. Can you see the impugn order? By reference 1 cited, this office has accorded the draft gated community residential layout, and as per which 3% of land was handed over to HMD, and access to the said land is by means of 30 feet wide layout. And as per directions given by this office, developer has dismantled the company. I earlier built a wall on the land which I donated, and they dismantled. Whereas it has come to the notice of this, we have constructed compound wall by blocking access to the land gifted to this office. So today the limited vacate we're asking is not on the 9,000, only as far as the donated land is concerned.
In fact, if you read this order, you are therefore directed to remove the compound wall constructed by you due to which access is blocked.
Right.
So the argument of Mr. Siddharth is that he should have access from the same community. That can't be accepted. That defeats the concept of gated community. It is not a Bagingapalli quarters.
Should I just say remove the block?
I will use it the difference. I will tell you.
Block, donated land.
1 second. 1 second. With that, you see, there is I'll tell you, a community, there can be a community like Baglingapalli. There can be a community developed by housing board like Kukatpalli or Vijayanagar Colony. That cannot be called as a gated community because the roads, everything is accessible by anybody, private, everything. So anybody can come in, go out. From Masap Tank, you go through internal Vijayanagar Colony, go to Mallepalli, permitted. Similarly, from RTC Cross Road, you come through Baglingapalli, come up to Narayanguda, no problem. Nobody is objecting because they don't call it as a gated community. Gated community concept is to ensure that the residents within the community have security, all controlled access, all those things. Once if we accept your contention and allow access to you, then that defeats the gated community concept.
Gated community concept, it does not defeat.
That we will consider.
Once the developer has gifted land in lieu of development charges, that's the kind of appreciate.
That is gifting. I'm parting, once again, I'm parting with my land in order to secure the balance land. Doesn't mean that I'm adopting you into my family. Sorry.
It is part of the layout.
No.
Lordships, I only request, please clarify the order. We will need to confine with respect to the rest of the land. For the donated land, today the issue is only for the interim vacate, was only for the donated land, not the rest of the land. That's the only point.
Rest of the land we are not concerned. That is the layout permission.
Yeah, today the association has built a gate on the donated land. That they can't do.
Nobody can claim that land because it is before they entered, actually before they purchased the land, you have gifted.
Yes.
So question of their claiming that land does not arise.
Well, the issue in order to now, because that the association has built the wall on the donated land, the HMD is denying approval for the rest of the land. Final layout they are not giving.
It's being held up and
so
unfortunately, no reasons are also recorded.
So only for the donated land only, Lordships may clarify that, and the rest we can argue in this.
No, actually, this is what is the concept of gated community. Okay.
But in that case,
in fact, somebody was making a mention to me about this kind of matters. Means number of matters are pending. Mr. Dhananjay Reddy. Sorry, we will accept. That's what. Yes, Mr. Counsel. What you have got to say?
Sir, very concept of gated community would be lost totally if such a thing is allowed. Well, there was a wall existing for the last 10 long years. So many NRS.
1 second. You are all people who have purchased a plot, 500,000, whatever is the size, and formed an association. First thing. What action the developer has done before you entered the picture is that he has gifted the property. Property becomes the property of HMDA for whatever reasons. The remaining properties is that of the developer, owner or the developer. Therefore, within that property, if he has made plots, sold, and provided access, controlled access, all that thing, you are all entitled to enjoy that. Nothing beyond that. Over, run, heard, reserved. I'll pass orders because there is no time. I will do it, Siddharth. Don't worry. I told you from starting from 2000. Now I will tell you. You know why they have done? I will tell you.
Yes,
2005 VAT Act came into picture. Then the definition of works contract was there staring at them. Therefore, how they wanted to today, a villa at that point of time was being sold at 1 crore 35 lakhs. They were required to pay VAT on that entire.
Entire.
So therefore, what they have done is they have entered into 2 agreements. One for sale of plot, so that the stamp duty, everything is on the cost of the plot. The other one is for construction by way of a separate agreement. I'm telling you.
But this blessed by the Supreme Court, it's tax planning.
It's a tax planning.
Yeah, not tax evasion.
No, tax evasion or planning.
There is an access for this land. 40 feet road is there. I have physically visited that area.
Was that fine?
They removed it.
You see, so builder polluted or not, once that land is delineated, that is the end of the matter. That becomes HMDS.
Final.
Clarify about final approval.
Lordship. So my plots with HMD.
No, that mortgage plots will be there, sir.
Yeah, mortgage plots are not being released because of this issue, my lord. So, my lord, as far as the donated land only, lordships may.
Yes.
Documents that the phase 2 is also not being released.
All that is fine. That's why, because you are creating problem. If this is done, something, if this is such a simple issue, we could have clarified HMDS right is only to the extent of land gifted. They have to work out their way from whichever this thing. That's the end of the matter.
Means carrying out the building, engineering, mining.
Again, Siddharth, this is, they have not gifted a building or anything. Simple thing. Today they have given a land to you, which you can utilize whichever way you want. But you are saying, I want the land, but also the benefits of the community. That is.
One more important was, 86, we have to provide access to the land behind us. That access also we have given already.
That is by the side, you see, there should be a, no, by the side of that layout, if access is provided, that need to be provided.
Lordship may clarify that, man.
If it is not there, if they do not have any other access, by the side, from one side, you can provide.
No, lordship may say these two things, my lord. Donated land and access to the side one. Exactly in accordance with that.
Yes, yes, next.
This is the building roads if others are not. Access road, if it is not there, what would the situation be?
Correct. That is what Siddharth, you remember, we have heard that Gumala Bhaskar Reddy and Pradeep Reddy's matter. Once there is a separate road provided in the layout to the land behind, because they can't be they can't be left as land out. So therefore, the developer or whoever it is will have to provide land to the, the layout or people who are behind the present layout. That has been taken care. That's the end.
My lord, these two issues, my lord. If access is given to this, as your lordship said, side blowners, and nothing can be done on the donated land.
See, otherwise, why that reason, that access to the plots behind. Otherwise, they will file a suit for
Easement right.
The aspect of giving access on a public road, cannot be blocked. That's a public road.
See, public road is different, sir.
It is vested in
Vested is only for the, I will give you a citation in my order, please. I look at that also. There is a Supreme Court judgment where it is said the roads which vest with the local authority, when a layout permission is being granted, doesn't become a public property. The public road, there is a separate procedure through which public road is to be notified. The road, internal roads and other things are only meant for the usage of the people. That's all. That is the end of the matter.
I'll pass on the division bench judgment.
Yeah. We had other colonies, the gift deeds which are given to municipality or cantonment board, the 40.2 is conditional gift deed, for the purpose of maintenance only. The owners invest in the property also.
This gift deed is not like that, man. It's not a conditional gift deed. It's an unconditional gift deed.
This is a Supreme Court judgment where their lordships arising from Punjab, Haryana, where their lordships have stated the vesting of the roads with the local authority is not.
No.
What their lordships held is, it is meant to be maintained by the local authority for the purpose of the.
That's for the rest of the land, man. Not the donated land.
It is over.
Yeah. The impede order is for building a wall with association on the donated land. That's kindly see para 11, my lord.
If it is constructed in a donated land, HMDA will be authorized to only after the land, only after the donated portion. That's why I simply said, originally this is the land. This portion is donated by Mr. Vivek Reddy's clients. So he will be entitled to present a compound wall up to this part, leaving this to Mr. Siddharth client, whether he wants to, whatever it is his property. A compound wall can be constructed this way, like this, so that nothing is visible to them and enjoy the property.
And it was demolished, we have to demolish it. And access has to be given to the side people.
1 second. Behind side, if you have constructed a 20 feet road, or as per GO 86, there is a prescription. If that is provided to the people who are behind your layout, that is the end of the matter. Thereafter also you can still construct. Here to do that.
Lordship, may clarify that.
Lordship, I appear for respondent number 9, the developer.
You just slip to the court officer. You want to say something?
Yes, Your
Who are you?
Merely because of the stay, we are not getting the occupancy, the OC or not.
That's the problem. Because I am the owner, developer. Because of this public road, they have erected a wall of the donated land. That's why they're doing it.
We will clarify that whatever is gifted over is.
Yes, I demanded an instance of HMDA, correct me not, because I can't touch the donated land.
They constructed 10 years back. They demolished it.
We will direct the demarcation of the land gifted and thereafter construct compound wall by the side of the demarcation.
And access to the site, people, madam. Access to the.
Which side people?
No, not like easement rights. The easement rights. One second, sir.
That the GO to 86 condition, if there is no alternate access to the lands behind, you are required to provide access from this.
Lordship may also see para 11 of the. Lordship may.
You may say that. Sir, alternate road in the village map should exist, not in your mind, my mind.
Para 10 and 11 of the judgment, man. There is not even, there is no declaration of direct community.
Fine. I've heard that's all over.
Okay.
Yes. Next, all the next matter.
We have already provided land for the organic land.
This is the IA 3 of 2021 filed by Siddharth. We have heard only Mr. Siddharth's IA. Because he is the only one advanced arguments. Others are not on record. No, because in your vacate, counter is to be filed. At least in his case, a counter is filed, so we have taken it as heard. When it filed, we will see who are you and all will be considered. Yes, come on. Next. No, order reserved. Yeah, your order will come. Don't worry. No question of adjournment. Having given a date and spent 1 hour. 89. Vacate.
This
1 second. 3, IA 3.
in this, I'm appearing for the writ petitioner. It relates to reconstruction of a house called Shangri, a dispute between the brother and sister. I'm not feeling well. May I request your lordship for an accommodation either next Wednesday or thereafter. I couldn't attend court today.
Matters will go to December. Subject to Mr. Vedul Venkatramana Sagi.
First week of December.
No. You are friends at the bar and force in the court. And no. That's why I'm saying you are friends at the bar and we will be seen as force at the bar, court, in the court. But next available date, December. 20th. 20th of December.
Very well, Mala. Stay may be extended. It's demolished.
There is till today.
Yes, it's till today. Last time, my lord granted 20th September.
At the request of Sri D.V. Sitharamurthy, Leonard, Senior Counsel representing for the under the same capture. Yes, next.
Item 90, Taran also for demonstration.
No, Siddharth. The man fighting that gated community litigation.
I just want.
Capture of the litigation.
I am just clarifying myself that what actually happened.
Yes, Sarang. In this matter, who is the vacate petitioner? If he is not ready, then what can we do? Ramchandar, you have filed vacate?
No. Respondent 10 has filed vacate. In fact, he is not even one of the parties in the. In fact, his plot is not even stood in the.
What do we do? Vacate or filed, mention is made. We give a date, they don't turn up. What do we do? Yes, Sridhar Rao. petitioner respondent number 10. He is not a party.
He's a party, Vinod.
Then why you have made him party then? He is entitled, since he is a party, he is entitled to seek for vacating the order.
What is saying that he's not even agreed by the order.
That you may say. He may say that I am agreed by the order, but unfortunately he is not there. What can we do? And though the respondent number 10 in the writ petition had filed IA 2 of 2023, seeking to vacate. Yes, Pradeep.
My lord, municipality has filed a vacate in this.
Very good.
But,
Yes, Ramchandra. 1 second. This is not a gated community.
It's not a battle for filing vacate even.
No.
Compulsion and filing.
You see, whenever I see Pradeep, he wants to disturb all gated community people, peaceful living, because he is opposed to this gated community living. He feels that these people are living peacefully, that I should not allow them to live. As it is that he does not know, there is, I'll tell you, in gated community, there is one more problem.
Maintenance and all other
It's
issues.
not only maintenance, Pradeep. Let us say in a 200 families are living, every gated community you will have 5 to 10 people, 10% of the people who are trouble creator. They will not pay maintenance. They will not pay common water bill. They will not pay common this thing, but they all want all the facilities.
Then they come to the municipality.
No, they all want all facilities. And they are the most conscious people, saying if they see a piece of paper or leaf, dried leaf, they will say the body is not working, the EC is waste, they will go to civil court, do all this nonsense, but they do not pay. And if you try to importantly, power failure, they use generator power for running ACs. While all others, we are all given 1 kilowatt load, which can only run lights, fans in every one room, 1 light, 1 fan. By getting private electricians, they will get it connected to their air conditioners, fridges, everything, and use it. These are the people in every community they exist. And Pradeep is the one who is protecting them.
My lord, I'm getting that sort of cases.
No. Yes. We should have some lighter this thing, no? In the after at the end of 3:30, we are entitled to have that kind of.
Yes.
What is this case?
Impugned order is at page number 16.
Page number
16 of the report.
15, 1-5.
16.
The user was asked to produce the permission copy.
Final notice. It's only a notice.
No, I'll just demonstrate.
1 second.
It's an order.
At the instance of unofficial respondent, Murad, this all a scam.
1 second. You got issued reply through advocate stating you purchased the loan from one Bagro. Hence, you are directed to submit building shed permission copy in respect of that situated at GP Fornala between 7 following with the and cancel the door number and it will be treated as illegal works demolished without further improvement. This is the order passed, Siddipet. Again, this order you came in writ petition.
Yes.
21/6/2020.
Initially, my lord, the first notice was issued at page number 18, where I've submitted my sale deed linked document, my lord, saying that there is a suit which is pending against.
No, where is that? Where have you furnished those documents?
My lord, along with the reply which is at page number 19.
Following as under, yes.
In reply, my lord, page 19. That is 6/5/23. To the notice of 4/5/23. Yeah. Sale deed.
Each case is that he purchased the subject property along with the structure.
Structure.
During the Gram Panchayat period.
Now
Based on the unofficial respondent complaint, municipality issued notice calling for the.
Now you have become a municipality.
Now issued a notice calling for that construction permission, copy of construction.
ఎక్కడి నుంచి ఉంటుందండి ఎన్నేళ్ల కింద బిల్డింగ్ ది అదర్ డే వి హావ్ సీన్ నో విచ్ దట్ మహబూబాబాద్ 30 ఏళ్ల కింద కన్స్ట్రక్షన్ మీరు ఇవాళ వచ్చి బిల్డింగ్ పర్మిషన్ తీసి పెట్టుకుంటే మీ రికార్డ్ మీ దగ్గర ఉంటుందా? మీ రికార్డ్ మీ దగ్గర ఉండదు కానీ కామన్ మ్యాన్ వచ్చి అడుగుతారు. యూ హ్యావ్ టేకెన్ పొజిషన్ ఆఫ్ ది రికార్డ్స్ ఫ్రమ్ గ్రామ పంచాయత్ ఆన్ బీయింగ్ అప్డేటెడ్ యాజ్ మున్సిపాలిటీ. No, no. So go and verify your record since when the property is under assessment.
It's the instance of unofficial respondent appears.
దానికి వెకేటే ఉంది, డిస్మిస్డ్. అసలు రిటైర్ డిస్పోజ్ చేయొచ్చా? ఎందుకు పెండింగ్ ఇక్కడ చెత్త రెసిడెంట్?
Official respondent also filed comment.
ఏంటి మరి ఉన్నాడా అడ్వకేట్ కూడా? All that is fine. What is your case? No. If there are disputes, civil dispute regarding the property, your remedy is to go to civil court.
Already civil suit is pending.
That's
OS
what I'm
96
saying.
of 20.
Rightly, you have gone to civil court. Municipal authorities cannot be used for this purpose. That order cannot be sustained. Right? We can close this writ petition. Okay, turn a burden. This writ petition is filed. Okay, IA 2 of 2023 is filed by the second respondent, by the petitioner who is second respondent in the writ petition, seeking for vacating the order dated 13/7/20, interim order dated 13/7/2023 in IA 1 of 2023 in WP so and so. Full stop. Since the issue involved in the writ petition relates to the respondent authority, respondent number 2, since the respondent number 2 relates to the second respondent authority in threatening to demolish the existing structure and interfering over the petitioner's house property bearing door number 21-10-5/2 at measuring 329 square yards in survey number 167 by AA and 167 by E/1 situated at old, what is GP Ponnala?
Gram
Panchayat Ponnala. Now under the municipality of Siddipet, without considering the reply dated 23/6/2023 submitted by the petitioner as being illegal. This has been illegal, arbitrary, against principles of natural justice. This court, instead of taking up the vacate petition as with the consent of the councils appearing for the party, had taken up the writ petition itself for hearing and disposal. Full stop. Petitioner contents. Content that she or he.
She, She is the one.
Petitioner content that content that she is the absolute owner and possessor of house bearing door number 21-10-5/2. Admission 329 square yards in survey number 167 by A and 167 by E by 1, situated at Old Gram Panchayat, Ponnala. Semicolon, and that the said house has also been assessed to property tax with PTIN number. PTIN number ena adi?
Yes.
Ramchandra, PTIN number 111-350-1386. So and so, having purchased under a registered sale deed from its previous owner in the year in December 2021. December 2021. 2021. 2021. Full stop. Petitioner further content that when the unofficial respondent number 3 tried to interfere with petitioner's possession over the subject property, petitioner had approached the competent court of civil jurisdiction and filed a suit seeking injunction restraining the third respondent and another from interfering with the petitioner's position. Ramanandi, final hearing. We are ready. Ready, Hariharan, ready. వెళ్ళిపోయారు అందరు. Mr. Danu, Surender Rao, not there. ఇది బండిల్ ఇవ్వండి. I directed it to be listed next week. Why is it come today? ఏం డేట్ ఇచ్చాను? ఇది కదమ్మా, మొన్న ఇంకోటి వచ్చింది కదా సురేందర్ రావు గారిది. ఇది మొన్నటిదా? మొన్న ఒకటి వచ్చిందండి లాస్ట్ వీక్. ఇది అది ఒకటి కదా? లాస్ట్ వీక్ సురేందర్ రావు గారిది ఒకటి ఉంది చూడండి. జీపీ ఫర్ మున్సిపాలిటీ, స్టాండింగ్ కౌన్సిల్ మున్సిపాలిటీ. మరి అది నేను వీక్ ఆఫ్టర్ ఇచ్చాను కదండి. వీక్ ఆఫ్టర్ అన్నాను యాక్చువల్లీ, ఎందుకంటే ఐ రిమెంబర్ దట్ టుడే we had this matter, Hariharan's matter. Next week పెట్టండి అట్లా. ఈరోజు ఏదొస్తే దాన్ని చూడండి.
Item 19 KV Rajendra Prasad.
ఫైనల్ హియరింగ్ ఎవరు చేయదలుచుకోలేదు. Ranu sir was there, no? His colleague was here. This is the difficulty. And I told them, everybody, that after the vacate petitions are there, if time permits, we will hear the matter. No, nobody is there. Ramchandar, which are the matters you are ready? Which can be disposed of? Item 23. Sri Prakash Reddy, GP. You are ready? Chinnappa Reddy. Praveen Virjala. Petitioner counsels. Nobody is there. What do we do? Come. We are waiting for you.
Sorry, Your Lordship.
Short 25, Amma. Everybody will come. You are supposed to argue the matter, balance. We are waiting for you. I told you in the morning. Half an hour, let us complete this matter. Because he was not there, we called your matter also. Come on. Anyhow, ఒకటి అయిపోతుంది. Yes.
Yes.
We were on the issue which I have framed.
Yes, sir.
ఎండోమెంట్ రమ్మనండి. జీపీ ఎండోమెంట్ రమ్మనండి. ఎవరు పొద్దున్న ఉండే కదా.
I'll do that at the end.
So the mute question is
Whether welfare of the animals as is performed by the
question is whether
looking after the welfare.
Whether the public see that page 100.
Yes.
Whether a society which is I was reading that one page.
Correct. 101.
101 is the copy.
Correct.
And the counter affidavit.
Yeah.
Of the endowment department, which is at page.
Third respondent, beginning from page 86.
86. 1 second.
Good.
is whether a society registered registered as a this was registered under public
No, this was originally registered as a company under the Deed and Hyderabad Companies Act.
company
Under the Deed and Companies Act, 1925. Narrated all that in the
companies act. But registered as a public
society under the Endowment Act.
Not Endowment Act. There is no word endowment then. That is what I was telling you.
Hyderabad Endowment Regulations 1348. Hyderabad.
Public charitable institution.
Yeah.
Registered Companies Act and registered as public
charitable institution.
Charitable institution. Can be brought under the purview of
1987. Act 30 of 87.
1987 Act. This is the simple question.
Yes. In that context, the court have to look into the object of the society.
Conversion of a public charitable institution, whether it can be converted or can it be treated as endowment.
Yeah.
Can it be considered as an endowment
merely
because the endowment also act also has charitable in it.
That's
the word charitable, which is adjunct with end.
Correct.
Are to be looked in isolation, or will it get color from the word Hindu?
Yes. In that context, kindly look into some provisions, then we can go into the impugned. Yes. Yes. Section.
1 second. Charitable and Hindu religious institution and endowments. So it is a charitable is also there. What is charitable? Purpose includes relief of poverty or distress, education. Charitable means any establishment, undertaking, organization or association formed for a charitable purpose.
Education.
Section 2(4).
Yes.
Defines charitable institution. And includes. So it's an inclusive definition.
And
includes, 1 second, includes a specific endowment. And Dharmadaya.
That we may not be concerned.
1 second. Let us see this applicability of the act.
Yes, sir. Section 1(3).
All public charitable
institutions and endowments, whether registered or not.
So public charitable institution which was there earlier, under which your society was registered, is also covered by this definition.
Whether registered or not, in accordance with the provisions of this act, other than work governed by the provisions of Work Act. And explanation is given in this clause. Expression public charitable institution and endowment shall include every charitable institution or endowment, the administration of which is for the time being vested in any department of government, civil court, Zilla Parishad, municipality or local authority, or any company, society, organization, institution, or other person.
So it covers.
This
Reading of
covers.
This at least indicates it
Correct.
covers.
This should be read with charitable purpose for which it is formed. That's where section 2.4 and 2.5 will come in.
When a word include is used.
Include is used, no doubt about it. But it will be related to the activities as prescribed for a charitable institution. 2.4 the court already has seen that. Means any establishment, undertaking or
Advancement of any other
formed
object,
for
utility or
purpose and
welfare to the
includes
general public or a section thereof, not being an object exclusively religious nature. 2.5D.
2.5 includes relief of poverty, education, medical relief, advancement of any other object of utility or welfare to the general public or a section thereof, not being an object of an exclusive religious nature. Now they sought to cover it under C, medical relief. Medical relief to the animals. Now they want to cover it under this.
So since it does not say only to public or person, human beings, medical relief includes everything.
That's what they try to interpret. Of course, they take.
1 second, medical relief. 2C. 2.5C, correct?
2.5C, medical relief.
No distinction between human and non-human. Yes.
They also take umbrage under 5D.
Right?
D. Advancement of any other object of utility or welfare to the general public or a section thereof.
Yes.
These two they combine to say that the veterinary hospital would come under
Charitable
institution. Keeping that in mind, kindly see the discussion in the impugned order. The impugned order begins at page 15 of the paper book. Look at this.
Yes.
Page 15 onwards. First para is.
Their stand now, para 5 is clear that they are trying to put it under that. Para 5 and what about your locus standi which they have raised as an issue?
In the backdrop of their own order seeking to proceed against me and the replacing the managing committee. That objection seems to be as a byword, but not as. But kindly see the order.
See, this particular institute was registered as the Society for the Prevention of Cruelty to Animals is a public charitable institution for the welfare of animals.
Yes. That's
So whether
from
the first
para 8
act applies only to humans or includes animals.
Correct.
One. Two, by having regard to the definition of 2.5C, the word medical relief is to be given a narrow meaning as applicable to human being, can also cover anybody and everything.
anybody.
Yes.
As I said, they also take umbrage under 5D.
First of all, if you let us say if this court comes to a conclusion that 2.5C, since it does not specify, because the legislature was conscious when they used 2.5D public in 2.5D public and such word is not used, it has to be given a wider meaning, then everything goes.
That's no, before that, the court were to see the narration of facts in the impugned order.
That you see, factual aspect to keep aside. Simple thing in this is applicability of the act.
No, I am trying to show what my object is, which is extracted in the impugned order. That will be easy for the court to. From para 8 of the impugned.
Yes.
The government of Hyderabad granted permission to the Society for Prevention of Cruelty on Animals to be registered as a company on 22/2/1932. This was accordingly registered under Section 26 of the Hyderabad Companies Act. The organization intended to apply profits and other income in promoting its objects and not to pay any dividend to members. In effect, it was registered as not-for-profit company. The memorandum of the association.
Something like Section 8 company.
Correct. Yes. Now.
1956 Act. Yes.
Then memorandum of association indicates the objects: prevention and suppression of cruel and improper treatment of animals and amelioration of their condition, generally throughout the HIH Nizam domain. In order to achieve this objective, the society employed paid officers to watch and prosecute persons found guilty of inanimity. It also started an infirmary to treat animals and provide refuge for animals incapacitated for work by reason of old age or due to some other reason. As per the petitioner in 1939, Nizam government through City Improvement Board allotted site for constructing a veterinary hospital. The building was constructed in 1940 and functioned from 1940 till 1988. The society was functioning under the provisions of Prevention of Cruelty to Animal Act 1330 firstly, and after Government of India Prevention of Cruelty Animal Act 1960 came into force, the society was invested with various powers by the state government.
One second, which is this endowment under which it was registered according to their order, para 12, 22/1/1959. This veterinary hospital society was registered as an endowment.
Correct.
Under the endowment rules. Which endowment rules?
Hyderabad.
No, but was it a public? That's why I'm asking. Was it the endowment or is it because this statement in para 12 is contrary to the statement recorded in para 24? That's why I'm asking, was it registered as an endowment or was it registered as a charitable trust?
Except for the Muntakab, which was read by this court, attached to the counter. I don't have other material on record.
States that the society is registered under endowment rules. Yes.
Then para 13, this is how he puts it.
Yes.
These two events, that is registration in 1959 and constitution of the board on 17/2/88, which is the impugned order. These two events have changed the character of the institution from a not-for-profit company to a public charitable institution. And it got registered as an endowment in the state endowment register way back in 1959. The
No,
request
come to
for
page para 21, 22. They discuss about the applicability of charitable institution. And their conclusion is in para 25. Your contention that it comes under Prevention of Cruelty to Animal Act and not a state act, and there seems to be no conflict. The society can function as an organization, so and so.
yes,
Ultimately, they say that you will fall under, you will have to be considered as a charitable organization falling under AP Charitable and Hindu Religious Institution Endowments Act 1987. There seems to be no provision that might create a confusion or problem in the.
para 23, they rely upon 5B. Para 23.
Yes, yes, we have taken note. Final conclusions are in para 25.
Correct. But the
Within the
discussion,
definition of
the
service.
discussion will show under what provision they are trying to treat it. That
Yes.
is at para 23.
Yes. Within the definition of section so and so, Act 30 of 19. It's a public institution run with public contributions and substantial government support, including original allocation of land by Nizam and subsequent funds and grants from Government of India. The second issue, no, we are not concerned with the second issue. That is what is the finding. Yes.
They themselves say at para 23.
Yes.
The question is whether prevention and suppression of cruelty and improper treatment of animals and the amelioration of their condition, which are objective of the society, can be called a charitable purpose within the definition provided under. Clearly, the definition above relates to charity in the context of human life, not animal life. However, an infirmary for treatment of animals or a
One second. I'll put this question. Please answer. Let us say you may be providing treatment to animals.
Correct.
Say that you are covered by PCA Act.
Correct.
Therefore, it is not. I have a trust.
Yes.
Society or whatever it is. Which I will give you Sadhuram High Hospital. It is a hospital, but it is run by Lions Club, which is a charitable institution. So, Lions Club, though runs, it's a charitable institution, but can it say that since the hospital, Sadhuram High Hospital, is providing medical this thing, therefore it cannot be, it is covered by MCI Act or whatever it is, therefore therefore it is not connected with the activity which I undertake, but the object.
Object of
So object is basically medical relief.
to the animals in question.
It doesn't say, it only stops at medical relief. That's what I'm saying. When the legislature said medical relief, irrespective whether animal, bird or anything, human being, or unlike you see, on the other hand in D, they use the word public.
Public.
So therefore,
But the authorities have put it on public purpose.
no, but otherwise also if it is providing medical this thing.
No, the whole section have to be read in half.
Okay, we'll consider.
And
yes,
find out if this is, because ultimately the.
1 second, Mr. C. If whole section has to be read as together, if everything, then they could have used the word public in the beginning in the section 5 itself. And everybody said medical relief, so and so, so and so. Why they use public in D specifically?
Because that relief of poverty and distress. This
That's
is
what I'm
related
saying.
to.
Relief of poverty.
This is related to human being.
That's what I'm saying.
Uh,
That we consider. Yes, understood.
Likewise, education related to human beings. Medical relief also will have to be read in that context, and D is very clarificatory for advancement of public companies. That's why it can be called as.
You say the act has no application to animals. It has only application to humans.
Because
they are worse than the animals.
Asking a question for myself, we have a organization, Harish Chandra Foundation. That's the class is my name. They
give
deal with dead bodies, bodies and burial, irrespective of caste, creed, or anything. Would they say it would be a charitable institution covered under this act?
Medical relief.
No, it's not a medical.
One second. Medical
person is
relief to
dead.
living being.
Person
Living
is
beings.
dead.
Medical relief to living being. You can't provide a medical relief to a dead
That's
person.
exactly what I am trying to point out.
Living being can be a human being as well as an animal. We'll consider. Not, I'm only not saying anything, but
Yes.
yes. That's all, nothing more in this. Come on, madam. What is your answer? You have 15 minutes more.
I have
Answer, no, madam. Over. Time is over. We'll have to close the matter. That's all. Your GP comes. If doesn't come, doesn't come. Matter is over. Madam, make alternate arrangement. We are not, madam, 2007 matter, I have no justification. Once having taken up being matter, have you seen the cause list? It is treated as a part heard. That's the end of the matter.
I've just cited two sites.
Yeah, please.
One is 1991, one ALT page.
1 second, 1991.
One ALT page 164.
ALT.
Page 164.
164, yes.
This is the Sai Baba Mandirs. The division bench was dealing with whether it can be called a religious institutions, which is connected to Hindu institutions or not.
No, that, see, that's what I'm saying. Which is whether the Sai Baba institution, which is specifically deals with the religious this thing, whether that comes under that or not is a different aspect. Charitable. Whether, I'll put it this way, let us say somebody, just taking example from the same case, a charitable institution, because you all know Sai Baba had this thing, a dog. No, that's why, the dog with him always. Correct. So if somebody who had this thing, he was a devotee of Sai Baba, let us say starts an institution for protecting dogs.
Correct.
Can it not be called as a charitable this thing?
Maybe
for
charitable institution.
For protecting, giving rabies injections.
My objection is these authorities will not have jurisdiction to it.
No, which authority? Because the word charitable here under the Act, there are two parts. Whether by virtue of the use of the word and, charitable and the word is Hindu religious. The word charitable applies irrespective of
the affiliation to any
particular religion.
Yes.
Hindu religious institution and endowment is specifically to
That's
Hindu.
right.
That is why, if you see the scope of the Act, it only excludes Waqf. Because that's a separate this thing. So So therefore, other than a Waqf, everything, if the object is intended to be a charitable in nature, that will get covered.
Incidentally,
the only thing is whether animals come within that or not.
Incidentally, it does not say anything about Christian institution, and endowment department does not control that.
Endowment may not control. Endowment is because endowment will get color from Hindu.
Charitable. If there is a
that's what I'm saying. Endowment.
The missionary doing charitable work, if the argument of the department is to be accepted, even Christian institution should get covered.
Where is the radio? Who controls Red Cross?
These institutions don't control.
Let us see. We'll consider. Yes. What is the other?
As a measure of argument, I am pointing out, nothing to do.
No, I'm just asking you, Red Cross.
Yes.
Because Red Cross is a society registered.
It's a society registered, a public society.
No, but that's what I'm saying. Public Societies Act.
Correct.
So which is like more like your this thing. Whether this will come under charitable institution, scope of the ambit of this.
That we are doing charitable work is not.
No, whether they are governed, let us say today, Red Cross is again to human beings.
Correct.
Whether they will come under this or not.
They won't come under.
Let us see. That is. Which is the other judgment?
The other judgment that is 2014.
2014.
5 SCC, page 75.
5 SCC, page 75.
This the court may note that the issue pertaining to administration of the Chidambaram temple in Tamil Nadu. I'll just read one paragraph. Whereas 7 and 15.
7 and 15, yes.
The right of charitable institution to administer it. 7 is Article 26 of Constitution for freedom to manage religious affairs, and it reads as
No, I have noted. I'll go through it. Any further point? Let us see, because we'll have to hear the other side.
Well, am
also.
I audible now? Sorry. There is one more issue. When they superseded the existing managing committee, there was no time limit or period, anything mentioned. There was not even an allegation against the existing trustees or society about any mismanagement. Because what this court is now testing is the original order dated 7/4/1988, which was subject matter of the revision and the writ petition, now remanded and come back. So in that order, firstly, there is no allegation against the trustees that they have mismanaged. Therefore, the very supersession of the trustees was erroneous. Secondly, there is no mention of what period they want to take up. Now, after 20 years also, by virtue of this litigation.
See, all that would come into picture only if we hold that you are covered by the charitable.
Correct, correct.
If we hold in your favor, there is no need to further discussion.
That's.
If that is it. Yes, madam, come on. Reply. You still have 6 minutes because we have other matters to take up. How many matters, Amma? Extension of interim orders. 11. 7. Madam, come on. Sorry, we will take it as heard. We'll take it as heard. Nothing. Over. I can't keep on kept, as a part heard every week. I have other matters to start. 2007 matter, please have some this thing. Mercy on the parties, councils, everybody. Okay. One second. Reiteration of counter averment. Right. Heard. Sri V. Hariharan, Learned Senior Counsel for the petitioner. G.
Just once in the previous 141, I stated that endowment did not file a counter.
No,
But
there
in
is
the
a counter.
booklet, I have found.
I've seen that. I've seen it in the lunch. Yes.
Right.
I have made to see Ramesh Sadhu GP from Fiscal Administration.
What is this number? Extension of yes, sir. Oh, so infractions matter. Who is appearing in this matter? None appears for the petitioner, none appears for the petitioner. ఎవరు ఒక్క నిమిషం 82లో
I have made to see Ramesh Sadhu.
GP for standing counsel for GP standing counsel for Karimnagar. Who is the counsel? Pravakar Rava. Matter on the cause surveys doesn't survey, they have to tell, no? Right. We'll close the Next.
Item 8 is status liability administration statement.
City. Srinivas, దీంట్లో కూడా same, none appears for the petitioner. There has been no appearance on behalf of the petitioner on 1810, 111. Even no, same, even same. Therefore, this court is of the cause. The petitioner.
Item 84 G Ashish Rao.
May I please lordship?
Yes, cause survives. What
Yes,
is the cause? Cause చెప్పండి చూద్దాం ఏంటో.
My lord,
Declaring
permit me,
not
page
taking
number
any action.
31. Page number 31, my lord.
Trying to construct a property of the petitioner in land in survey number plot and admitting so and so without obtaining permission. According to you, no permission, correct?
Permission and my permit to page number 31, my lord. Survey report was given by the director survey land.
One second, we are not concerned with the civil disputes. Simple thing, whether the permission has been obtained for construction or not.
Not obtained.
That is what we are required to see. Who is appearing? This is which principal
Mahbub
secretary? Mahbub Nagar.
Yes, my lord.
Ramon Reddy garu meede. Permission unda leda andi 2014 matter. Some mercy we should show on these writ petitions.
2014 millet.
That's why I'm saying. Why? That's why I'm saying whether permission exists or not. The matter had come up on 2 occasions earlier, 1810 and 111.
Finally millet on Tuesday millet I will.
Next Wednesday, same.
Yes.
At the request of Sri M. Rammohan Reddy. Whether permission is there or not, other civil dispute, they have to work out their remedies and 226 is not to resolve their civil disputes. Sri M. Rammohan Reddy, Learned Standing Council. Yes. Bhai, bolo.
Last time, it was addressed for that waiting for it as a way of last intelligence, it will take them.
Next week, finally. Next week, finally. At the request of counsel for petitioner, next week, finally. Yes, next.
Item 8 is 16 months of areas and from municipal administration.
Same. Durga Prasad. Standing concern, so seeks further time to get instructions. Where is it? Yeah, instructions ఏంటి వచ్చో కాస్ సర్వైవ్ అవుతుందా లేదో చెప్పొచ్చు కదా. పిటిషనర్ రాడు వీళ్ళు రారు ఏం చేస్తామయ్యా. 10 ఏళ్ళు అయింది రిట్ పిటిషన్ వేసి. ఇప్పటికి 3 అడ్జర్న్మెంట్లు అయినాయి. ఎందుకు 2014 మ్యాటర్ ఎత్తికి తీసి డేట్లు ఇవ్వటానికా. Heading ఏం పెట్టని చెప్పు. Specially mentioned cases infractures. Right. Same council for standing council. Finally, 6 weeks time, list finally. Next week, yes, next one.
May it please, your lordships, for the petitioners, we have sent a legal notice through RPID to pursue the case, my lord.
You have sent a
Kindly 1 week may be given.
మీరు అసలుకే తీసుకో. మీరు లీగల్ నోటీస్ పంపిస్తే అసలుకే తీసుకోడు పార్టీ.
To know the present position, please kindly give us 1 week time, my lord.
Finally, లేకుంటే క్లోజ్ చేస్తాను. If client is not interested, if he has not visited your office, is not interested.
Our senior counsel has been appointed as a designated senior advocate.
If the client has not come to your office beyond 1 year, that means he is not interested in the case. Because he must be thinking that if he comes to your office now, you will have to pay some fees. That is why he is not coming.
Otherwise, kindly delete our senior counsel name from the cause list.
You have to file a wakalat. We can't delete it just like that. File a wakalat if you want. Otherwise, finally. Yes, next.
Obliged, Your Honor.
Same. Who is appearing? Any vacate not filed, counter not filed, counter filed? Counter affidavit on behalf of, sorry, pleadings complete or nothing. After 4 weeks. Yes, next interim order to continue. Next thing.
You can file for extension of interim order. Lords may extend the interim order for a period of 2 weeks, my lord, I file.
Counter is not filed. Yes.
May it please this honorable court. I beg to represent T. Rahul, my lord.
Counters.
Counters are filed, my lord. Two counters are filed. We have filed our reply also, my lord.
1 second. Pleadings complete. Pleadings complete. List the matter for final hearing in the usual course. Interim order granted.
Item 95, Chandrasingh Office and State Municipal Administration, Evidence.
My lord, I'm for the petitioner, my lord. No counter has been filed, my lord.
No counter is filed. 1 second, Durga Prasad. Sri M. Durga Prasad, learned standing counsels appearing for respondent 2 and 3/6, further time to file counter in the matter. List after 4 weeks, interim order to continue. Yes, next.
May I please vote? I am for petition, Lord. Counter was not filed, Lord.
Who is the other side counsel? Durga Prasad. Same. Srinivas, come. Sri M. Durga Prasad, learned standing counsel 6, further time to file counter in the matter. List after 4 weeks, interim order to continue. Next.
His lordship, yesterday in connected matter, His lordship disposed the writ petition directing the petitioner to file first appeal under section 252. Same order may be passed. Writ petition number 21623. Writ petition number 216.
WP number
21623.
623
of 2023.
Nakrekalda.
Nakrekal. Nakrekal.
Appeal 252.
Yes.
Same order can be passed. What is the date of the order? We'll pass order. The writ petition is disposed of. Writ petition disposed. Make that formal same order 621623.
Arising out of same order, Lordship. In same premises, there are 3 shops.
Well, that is fine. But okay, same order. Fine, same order. 252. Appeal. Same 3 weeks. అందులో 3 weeks ఇచ్చినట్టున్నాను.
3 weeks.
Same. Disposed. Yes. Next. Yes, Dhananjay.
Return instructions for that, the doctor may send the order for that.
Right. Sri M. Dhananjay Reddy, learned standing counsel 6, further time. How many matters you are giving? All the standing counsels, you are not there. Wherever speaking orders are there, both municipality and GHMC, please give the writ numbers. We'll get it listed so that we can relegate them to 252 or 645455. Everything wash off from this court. 12/6. That will take it up. The identified cases కింద వేసుకున్నామా అవన్నీ వాళ్ళు లిస్ట్ ఇస్తారు. We'll list all of them at one go. Please give. When will you give?
Other infectious matters
No, not that infectious matter. First give the speaking order. You see, wherever speaking orders are there in GHMC, please give that so that we can ask them to go and challenge that in under 654 and 655. Similarly, municipality, whoever is municipality standing counsel, give that list. We will direct them to file appeals under 252 by giving 3 weeks time. Let us close all these matters.
By Monday we'll prepare this.
Some matters, please give that list. Monday is too long, then we're ready. If you can give us by some Friday, we can do some exercise.
Otherwise, they will bounce upon us. Why did you give the number?
No. Tell us court has taken it. I am also trying to do it. You see, I am asked my registrar CPC to write a program through system it can pick up. That we are doing. And that we will do. Not that we are not leaving any stone unturned. We will do that. I only requested because you may have a specific subject wise so that it will be easy. Neevemanunaya Babu? Closed Jeshavi. Where you are creating trouble for people living. Comfortable living, you are creating trouble.